Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020? 7:44 p.m. How, does the FBI find people? The people's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Alrighty, welcome back to the Court of Public Opinion. I am the Recovery Addict. Welcome, welcome. It's good to be here. I think you can see me. What do you guys see? Okay, that's good. All right, we're going to go back to court right now, which is starting like a minute ago. So we're going to speed watch and watch for about 4 minutes, get caught up here. Here we go.
You only submitted the map, is that correct?
Yes.
Okay,
All
and so then you can go ahead and look at make sure everything's admitted that you want admitted.
We're going
And
to
I
turn
think I marked on the back of all of them, but if I didn't.
turn the volume down. Quick recap on the case. This is well, first of all, SF in Texas. Thank you very much. First in chat today, this afternoon. Congratulations. The internet's all yours. We are going back to court. We're in Thurston, Washington, where the defendant in a blue shirt, much like my own, but that's not me, is charged with aggravated assault. 2 counts of aggravated assault and reckless driving in a road rage incident that involves him and 2 younger females. He was in a big truck. They were in a Toyota Corolla. Apparently, there might have been some racing, some jockeying for position, and then depending on who you believe,
the flash drive, it's that.
Some
I'm not sure where
violence.
that is. It'll go back then with
Some
them,
violence.
but they won't have the opportunity to play it unless they ask for it.
The
The flash drive is up here already. All right. The computer.
The state has rested their case.
And
They're just sorting out some details here.
Yeah, it's attached to the laptop.
That's the prosecutor you see there with his arm out in a weird angle.
Yeah, I plan to. So.
okay. Great. You go ahead and keep those. Let's go back and take that instruction. Okay, you ready to bring in the jury?
Yeah, the state's ready.
Is this the right one?
And then I still need to be on the record. Got it. Okay, go ahead.
I think we're the right one. How is Mrs. Aria's foot? Okay, I don't think the toe is broken, but I think she's completely lost her big toenail. It's like just all one piece off. But I think it hurts her when I talk about it, so we can't do that. Yeah. It's like the worst possible way to stub your toe. So when it's still attached to the cuticle, then what? What do you do now? Just wait? I think we need to buy a gallon-sized bucket of lidocaine or something so you could dip your foot in it, and so it doesn't hurt as much. Yeah. Epsom salt soak.
You can be seated in the courtroom. And so when we broke, the state had arrested Mr. Pazderka.
You're under defense arrest.
And
Defense
so members
arrest.
of the jury, when
Whoa!
you came back out, I see you all have in your hand now the copies of the court's jury instructions. The evidence portion of the trial has been concluded. So what's going to happen now is I'm going to read the instructions on the law to you. Following that, you'll hear closing argument from counsel. So I've observed over the years, different people have different learning styles about how I read these instructions. Some people follow along as I read them. Some people just hold them and then review them when they get back in the jury room. Whatever your reading or listening style is fine with me. But the law that will apply in this case is as follows. Instruction number 1. It is your duty to decide the facts in this case based on the evidence presented to you during this trial. It is also your duty to accept the law for my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law for my instructions to the facts that you decide have been proved, and in this way, decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true, and your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberation consists of the testimony that you have heard from witnesses, stipulations, and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reason for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss the evidence during your deliberations or consider it in reaching a verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You're also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things that he or she testifies about, the ability of the witness to observe accurately, quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome of the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you. And you must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on a lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatever to do with any punishment that may be imposed in case of violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions, and during our deliberations, you must consider the instructions as a whole. As jurors, you are officers of this court, and you must not let your emotions overcome your rational thought process. Then you must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially and with an earnest desire to reach a proper verdict. Instruction number 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based on further review of the evidence in these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3. The defendant has entered a plea of not guilty.
1 year.
That plea puts in issue every element of the crime charge. The state is the plaintiff and has the burden of proving each element of the crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists as to these elements. The defendant is presumed innocent. This presumption continues throughout the entire trial unless, during your deliberations, you find that it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists. It may arise from the evidence or lack of evidence. It is such a doubt that as would exist in the mind of a reasonable person if they're fully, fairly, and carefully considering all of the evidence or lack of evidence. If, from such consideration, you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Instruction number 4. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One, not necessarily more or less valuable than the other. Instruction number 5. The defendant is not required to testify. You may not use the fact that the defendant has not testified to infer guilt or prejudice him in any way. Instruction number 6. A separate crime is charged in each count. You must decide each count separately, and your verdict on one count should not control your verdict on the other count. Instruction number 7. A person commits the crime of assault in the 4th degree when he or she commits an assault. Instruction number 8. To convict the defendant of the crime of assault in the 4th degree as charged in count 1, Each of the following elements of the crime must be proved beyond a reasonable doubt. That on or about February 4th, 2024, the defendant assaulted Emma Hammersley, and 2, that this act occurred in Thurston County, Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 9. To convict the defendant of the crime of assault in the 4th degree as charged in count 2, each of the following elements of the crime must be proved beyond a reasonable doubt. 1, that on or about February 4th, 2024, the defendant assaulted Alyssa Campos, and 2, that this act occurred in Thurston County, Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 10. An assault is an intentional touching or striking of another person that is harmful or offensive, regardless of whether any physical is done to the person. The touching or striking is offensive if the touching or striking would offend an ordinary person who is not unduly insensitive. An assault is also an act done with intent to inflict bodily harm, bodily injury upon another, tending but failing to accomplish it, and accompanying with the apparent present ability to inflict the bodily injury, if not prevented. It is not necessary that bodily injury be inflicted. Instruction number 11. Bodily injury means physical pain or injury, illness, or impairment of a physical condition. Instruction number 12. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Instruction number 13. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result when he or she is aware of that fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted, but not required, to find that he or she acted with knowledge of that fact. When acting knowingly as to a particular fact is required to establish an element of the crime, the element is also established if a person acts intentionally as to that fact. Instruction number 14. No person may, by any intentional act, reasonably likely to provoke a belligerent response, create a necessity for acting in self-defense or defense of another, and thereupon use, offer, or attempt to use force upon or toward another person. Therefore, if you find beyond a reasonable doubt that the defendant was the aggressor and the defendant's acts and conduct provoked or commenced the fight, then neither self-defense nor defense of another is available as a defense. Words alone are not adequate provocation for the defendant to be the aggressor. Instruction number 15. It is a defense to the charge of assault in the 4th degree that the force used was lawful as defined in this instruction. The use of force upon or toward the person of another is lawful when used by a person who reasonably believes that he is about to be injured by someone lawfully aiding a person who he reasonably believes is about to be injured in preventing or attempting to prevent an offense against the person, and when the force is not more than is necessary. The use of force upon or toward the person of another is lawful when used in preventing or attempting to prevent a malicious trespass or other malicious interference with real or personal property lawfully in that person's possession, and when the force is not more than is necessary. The person using the force may employ such force as a reasonably prudent person would use under the same or similar conditions as they appear to the person, taking into consideration all of the facts, circumstances known to the person at the time of the incident. The state has the burden of proving beyond a reasonable doubt that the force used by the defendant was not lawful. If you find that the state has not proved the absence of this defense beyond a reasonable doubt, it will be your duty to return a verdict of not guilty. Instruction number 16. A person commits the crime of reckless driving when he or she drives a vehicle in willful or wanton disregard for the safety of persons or property. To convict instruction number 17. To convict the defendant of reckless driving as charged in count 3, each of the following elements of the crime must be proved beyond a reasonable doubt. 1, that on or about February 4th, 2024, the defendant drove a motor vehicle. 2, that the defendant drove the vehicle in a willful or wanton disregard for the safety of persons or property. And 3, that this act occurred in Thurston County, Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 18. Willful means acting intentionally and purposely and not accidentally or inadvertently. Wanton means acting intentionally in heedless disregard of the consequences and under such surrounding circumstances and conditions that a reasonable person would know or have reason to know that such conduct would, in a high degree of probability, harm a person or property. Instruction number 19. A vehicle is any device capable of being moved upon a public highway and in, upon, or by which any person or property is or may be transported or drawn upon a public highway. Instruction number 20. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard in every question before you. Deliberations are to occur only in the jury room when all 6 jurors are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If, during your deliberations, you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you have taken during the trial if you wish. You have been allowed to take notes to assist you in remembering clearly and not to substitute for your memory. The memories or notes of other before your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory and as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If, after carefully reviewing the evidence and instructions, you feel the need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly, and for this purpose, use the form provided in the jury room. In your question, do not state how the jury has voted. The presiding juror should sign and date the question, give it to, says bailiff, but in our case, it's clerk, and I will confer with the lawyers to determine what response, if any, can be given. You will be given the exhibits submitted into evidence, these instructions, and verdict forms for recording your verdicts. Some exhibits and visual aids may have been used in court, but will not go with you to the jury room. The exhibit that have been admitted into evidence will be available to you in the jury room. You must fill in the blank provided in the verdict form the words not guilty or the word guilty according to the decision you reach. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. The presiding juror must sign the verdict form, notify the clerk, and the clerk will bring you into court to declare your verdict. Those members of the jury are my jury instructions, and the instructions will apply in this case.
Closing arguments are next.
Please give your attention to Mr. Holcomb for his closing argument on behalf of the state. Mr. Holcomb.
Christine, you're welcome to grab it from Thurston. I'd rather you not use my full stream unless you're just doing
turn this a little bit.
But
okay.
I have songs and things that I pay licensing for that might hurt you.
Okay.
If you just restream my stuff. Patricia, congratulations.
Thanks for being here again. You made it. You made it to the jury, and now you've made it to the end of the trial where we've heard all the evidence portion. Now it's time to tie it all together. And as I said at the start of this, now it's my job to attach all the evidence that has been heard and attach it to the elements of the crimes that are charged. So the judge just went through all of the jury instructions with you. There were 20 of them. There were multiple pages of them. And I think that it would do a lot of benefit for us to be able to go through those to hone in on what are the key issues in this case and how they directly attach to the jury instructions. So you know where to start when you are working on your deliberations. So first of all, big picture. As I said at the beginning, an incident occurred and you have two different stories as to what happened in this case.
I think we have three.
You have the side that was provided by Emma and Alyssa, which is supported by the testimony, both of Emma and Alyssa, as well as in part Miss Jean Wright. We also have the photos of the car and photos of Alyssa's face. We have the video of the altercation, and I'm going to focus on this when we get to the assault part, but that very much supports what Alyssa and Emma, their version of events. And on the other side, we have a second story. This second story, the evidence to support that is the defendant's own statements. And that's it, which, by the way, are directly contradicted by much of the evidence that was provided that supports Alyssa and Emma's account of what happened that day. So we're going to dive into what happened for both the reckless driving count and the assault count. And you'll have to forgive me here. Reckless driving in the jury instructions does appear later in the jury instructions, but I'm actually going to focus on the reckless driving elements first, just because chronologically in the order of stuff that happened, reckless driving is going to be the first one that we talk about. So when we're looking at the evidence and how it connects, one of the things you want to focus on is actually, we are going to start at the beginning. If you go to jury instruction number 1, it's a rather large instruction. But there's a reason that it's at the beginning, and that reason, in part, is on page 2, where they talk about how you as the jury are to examine the evidence. What magnifying glass are you using to look at what you are being given? How are you going to judge the credibility of the evidence? And if you go to the second paragraph, it says, you are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. So you guys are the judge. You are the ones who determine whether someone is credible or not, whether someone is believable or not. I do not decide that. Defense counsel does not decide that. The judge does not decide that. You are the sole judges of credibility. So, and then we go down to the third paragraph, and it talks about what you consider when looking at credibility. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about. Earlier, during jury selection, I talked about how when you're given two sides of story and people are witnessing it from different directions, those accounts may differ a bit because they have different perspectives on what's going on. They have a different intimacy of what's going on. They're either in the thick of it, or they're observing from the side, or they're just a bystander, or they're someone who's taking someone's statement at the end of it. So that is something to really focus on when you are assessing credibility. The next is the quality of the witness's memory while testifying, the manner of the witness while testifying, any personal interests that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown. Next is the reasonableness of the witness's statements in the context of all the other evidence, which I believe was briefly talked about by juror number 2, now number 1, talking about, and I think that other jurors also talked about this, of we're going to examine the statements in the context of everything else.
Whoa,
do their statements contradict everything else, or does what they're saying line up with everything else we are being presented? The next is any other factors that affect your evaluation or belief of a witness or evaluation of his or her testimony. So, in other words, this list is not exhaustive. There are other things that you can consider as well. We're going to dive more into this into the assault, but believe that the stature, height of the individuals involved can become relevant, and we'll go more into that when we get to the assault piece. So now, reasonable doubt. We talked, if you go to instruction number 3, again, the reason that I'm going over this one is because this reasonable doubt standard applies to all of the elements we are going to talk about today. Every single one of those elements must be proven beyond a reasonable doubt. So jury instruction number 3 is a really important instruction because you're going to be using it for literally every single element of every single crime that is charged. So instruction number 3, the defendant has entered a plea of not guilty. That plea puts into issue every element of the crime charged. State is the plaintiff, so the state has the burden to prove it. The defendant is presumed innocent. This presumption continues throughout the entire trial, unless during your deliberations, you find it to be overcome by the evidence beyond a reasonable doubt. And then the third paragraph is what I really want to focus on because it defines reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt that would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. And this last sentence here is really important. If from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. So abiding belief. In other words, are you convinced? Are you convinced? We talked earlier about snow outside your house.
This statement of the law.
I'm going to overrule the objection and remind the jurors that the lawyer's statements and arguments are not evidence or the law. The evidence was what was presented. The law is contained in my instructions. And with that, you may continue.
Abiding belief. It's a belief that stays around. It's something that sticks with you. You are convinced. Are you convinced? Are you convinced? That's all that it means. So earlier we were talking during voir dire about looking out the window and seeing snow on the ground. And I said, hey, what happened? And then immediately everyone was like, it snowed outside. Like immediately, right away, everyone's like, yeah, it snowed outside. And I was like, would a weather report have been helpful? Sure. Would looking at the snow and examining it under a microscope, would that have been helpful? Sure. Was it necessary? No, it was not necessary. All you had to do was look out the window. You saw snow on the ground. It's December. It snowed outside. So the question is the evidence you are given today sufficient to convince you? That's all that it means. Is the evidence I present sufficient to convince you of each of the elements of the crimes that are charged? So now that we have that background, we're going to dive into the crime alleged of reckless driving. So this is unfortunately the part where we have to skip towards the end. Instruction number 16 is the introductory instruction to reckless driving. So a person commits the crime of reckless driving when he or she drives a vehicle in willful or wanton disregard for the safety of persons or property. So what does willful or wanton disregard mean? Well, I'm glad you asked. If you go to instruction number 18, it specifically focuses on what wanton and willful disregard means. So first is willful. Willful means acting intentionally and purposefully and not accidentally or inadvertently, meaning you knew what you were doing. You knew what you were doing when you did it, and you did it. That's what willful means. Wanton. Wanton means acting intentionally in heedless disregard of the consequences and under such surrounding circumstances and conditions that a reasonable person would know or have reason to know that such conduct would, in a high degree of probability, harm a person or property. So what does this mean? It means it's not subjective. This isn't just you personally, hey, I didn't know that it was dangerous. I didn't know that. The question is, would a reasonable person in your position know that what you were doing was dangerous to those around you? Would a reasonable person know that? That's what wanton means. So willful means that I knew what it was, I did it anyway, and wanton means that a reasonable person would have known. So now we're going to instruction number 17. So in criminal law, there are these things called elements. So elements are the building blocks of the charges. So when you look at instruction number 17, you'll see there are three numbers on that page. Each one of those is a building block that leads to the charge of reckless driving. If any one of those is not met, then the defendant is not guilty of reckless driving. Each one of these three bullet points needs to be proven beyond a reasonable doubt. So going to the first one, that on or about February 4th, the defendant drove a motor vehicle. There is no dispute about this. That there's no dispute that the defendant was the driver that day. There's no dispute that it happened on February 4th. There's no dispute that it happened, that the defendant was driving that day and that it happened on February 4th. So we can check off number one. That's one of the easy ones. Then we'll skip down to number 3, because that's another easy one, that this act occurred in Thurston County, Washington. There's no dispute that this happened in Thurston County, Washington.
The road does go in Thurston.
Many of you may be familiar with the area. A trooper who works in the area said, yes, this was in Thurston County. So that's not disputed at all. So we can also check off number 3. 3 is met. So now the real meat of the reckless driving charge here is number 2, that the defendant drove the vehicle in a willful or wanton disregard for the safety of persons or property. So, and we already talked about what willful or wanton means. So let's look at the evidence. What does the evidence say? How does the evidence describe the defendant's driving pattern on that day? And again, when we're looking at this, we're looking at the defendant's actions. The question is what the defendant did, is what he did satisfy the elements? We're not focusing on everyone around. We're not focusing on everyone around the circumstance except for how it relates to his actions. That's what we are focusing on. So looking at the evidence, the testimony of Alyssa and Emma and Jean Wright are all evidence that support the charge of reckless driving and reckless driving in a reckless manner. So Jean Wright, so that was the individual who wasn't in the vehicle. She was the bypasser, indicated that the defendant and Alyssa and Emma, that both vehicles zoomed past her at a high rate of speed. So both vehicles are doing this. We're focusing specifically on the defendant in this case, but both vehicles zoomed past her well over the speed limit. She said she was going 55, and the other vehicles were going way past her. So we know both these vehicles are going fairly fast, at least according to the testimony provided by Jean Wright. So Alyssa and Emma indicated that the defendant gained on them rapidly from behind. He said that there was a truck that was, sorry.
What? That was yucky.
It said there was a truck that was gaining on them quickly from behind. Both Alyssa and Emma said that the defendant had his high beams on as he was approaching their car and getting really close to their car. So what's the problem with this? What's the problem with having high beams as you are rapidly approaching another car? It blinds the driver. And in fact, to this day, on this incident, he blinded 2 drivers. He blinded both Emma, who got the meat of this incident, and he also blinded Jean, because as Jean said afterwards, she said that she was blinded by the lights of the truck that were behind her. And we know that that was Mr. Roswall's truck. So he's driving at a high rate of speed. He's approaching another vehicle rapidly. He's getting very close to that vehicle, and he has his brights on. And Emma and Alyssa said that in response to these bright lights blinding them, they slowed down because they couldn't see very well where they were driving. This happened at night. They couldn't see where they were going, so they slowed down. In response, the defendant is alleged to have swerved into the side of their vehicle. Emma and Alyssa both said, yeah, he tried to swerve into the side of our vehicle, and Emma had to drive off the road to avoid a collision. And both Emma and Alyssa said, yeah, had we not driven off the side of the road at that point, he would have hit us. So
emphasizing the point.
After that happens, the truck passes them, comes to a sudden stop in the middle of the roadway. A
content warning, little language in this one. I feel his pain. Oh my goodness. As somebody who has a microphone in front of him 8 hours a day and every noise I make gets picked up, I feel so bad for him. I can laugh because it's happened to me.
State's Exhibit number 2. This is the video. I'm going to mute it just for purposes of this.
Just because it makes the victim look really bad.
He is in the middle of the road. He is not on the shoulder. He said that he told the officer that he pulled off to the shoulder to let them pass. That's not what happened here. He is in the middle of the lane. He is smack dab in the middle of the lane. He stops smack dab in the middle of the lane suddenly, forcing the car behind him to also come to a sudden stop. There's not a stop sign here. There's not a light here. He just stops in the middle of the road right in front of another car, and it causes the Emma and Alyssa to come to a sudden stop. This is reckless behavior. This is dangerous behavior. This is behavior that could have led to Emma and Alyssa and himself suffering injury here. This could have seriously damaged their vehicle. Another thing to consider is the fact that his truck is large.
I really
this is
like
a large
this prosecutor.
truck. It was high enough up that it blinded two drivers because the headlights were at where the drivers were at. This is a large truck driving recklessly alongside another driver, then stopping dead in front of them. He then gets out of his vehicle, blocking the left side. You can see the driver's side door opens up onto the left side. So he's completely blocking this road. So the elements of reckless driving are met. First of all, clearly this happened on February 4th. So number one's done. Clearly the defendant was driving. He's in the video. There's no contest that he was the one driving. This happened in Thurston County. The officer said it happened in Thurston County. There's a map that shows that it's in Thurston County. And finally, this is extremely reckless behavior. And what you think of other cars on the road doing at that moment is irrelevant here. Because the question is, did his actions amount to reckless driving or not? Mrs. Wright described how both vehicles were speeding. She said both of them were driving side by side on the roadway. The question isn't whether Emma and Alyssa were driving recklessly. You may not agree that Emma and Alyssa handled this the best way they could have. You may not believe that. But the question is what he did reckless? Is what he did reckless? That is the question. So all the elements for reckless driving are met. So that was the first charge. So now we're going on to the second charge. So if you want to go to instruction number 7, we're going to go flip back to the front again.
How long does he have for his closing? I thought he only had 15. Are they giving him half an hour?
So number 7, a person commits the crime of assault in the 4th degree when he or she commits an assault. So I don't know if anyone's ever told you this about definitions where you probably shouldn't include the word inside the definition. So thankfully, we have a slightly more helpful instruction on number 8. So our number 10, actually. Number 10 is the definition of what an assault is. So, but number 8 is the element. So first we'll turn to number 8. This is going to be very similar to reckless driving, where 2 of the elements are really easy, and then we'll move on to the meat of the deal. But again, each element has to be met, so I need to attach the facts to each of the elements. So just be patient. So instruction number 8, to convict the defendant of the crime of assault in the 4th degree as charged in count 1, each of the following elements of the crime must be proven beyond a reasonable doubt. Number 1, that on or about February 4th, the defendant assaulted Emma Hammersley. So half of that is not disputed at all. This was on February 4th. It happened in 2024. So we'll move on to number 2, that this act occurred in Thurston County, Washington. Again, this happened in Thurston County, Washington. All the evidence, all that's met. So the real question is, we're going to focus on whether or not the defendant assaulted Emma Hammersley. And for that, we're going to go to that oh so helpful definition that I said was on instruction number 10. So during jury selection, we talked about 2 different types of assault, and that's where the jury instruction number 10 comes into play here. There's the assault where there is physical contact, there's actual physical contact, and then there is an assault where there is the intent and ability to use physical contact, even though the physical contact didn't happen. So what does that mean? It means you don't get any credit for missing your punches. That's what it means. You don't get any credit for missing the punch. There was the example of something is thrown at the wall. Like someone said, a glass object was thrown at the wall and you missed someone, but I scared you. I intended to scare you. So that's where that definition comes in. And that definition actually is the one that applies to Emma. So Emma is the one who is driving. Emma doesn't get out of the car until the defendant starts walking away. So she's in the vehicle for the vast majority of this incident. So the 2 instructions for, if you look at instruction number, I think it was number 8. Number 8 is for Emma and number 9 is for Alyssa. If you look at the first bullet point in number 8 and number 9, the only difference between the 2 of them is number 8 says Emma and number 9 says Alyssa. So they're the exact same elements, just for 2 different people. So just clearing that up real quick. So Emma is in the vehicle the whole time. There was no physical contact with Emma. So the state is not alleging that the defendant put his hands on Emma. The question is, were his acts sufficient to qualify under the second prong in number 10? An assault is also an act with intent to inflict bodily injury upon another, tending but failing to accomplish it, and accompanied with the apparent present ability to inflict the bodily injury if not prevented. It is not necessary that bodily injury be inflicted. So that was 3 stanzas of a lot of verbiage there. So let's just break it down. So an assault is an act done with intent to inflict bodily injury upon another. So what was the act here? The act here is when the defendant gets out of his truck, blocks them from leaving, walks up to the window, and slams his foot 3 times in the driver's side window directly next to Emma's face. Emma's sitting in the driver's side. She's small in stature, just like Alyssa is also small in stature. She's sitting there, and he strikes the window 3 times with his foot with sufficient force to, in her words, shake the truck. And it caused her a lot of fear.
Car.
She was afraid.
Toyota Corolla.
She was scared that he was going to break through that window. And if he breaks through that window, he could cause serious damage to her. And that's clearly obvious based on the statures of the individuals who are involved in this case. The defendant is clearly much, much taller than the victims in this case. So, tending but failing to accomplish it. He failed to accomplish it. Thank God he did not make physical contact with Emma. So, failing to accomplish it and accompanied with the apparent present ability. He's a large guy. He's got a lot of muscle, and he's able to lift his leg high enough that it's striking the window, and it's striking it with sufficient force to cause concern for those in the vehicle, both enough for Emma to fear for her safety and enough for Alyssa to feel the need to get out and confront him so that he has to stop banging on the door. That's the reason that Alyssa exits. She says that she was afraid for Emma. She was afraid that he was going to break through the door. So she got out. To inflict bodily injury if not prevented. Again, the door prevented it. It is not necessary that bodily injury be inflicted. You don't get any credit for missing your punches. You don't get any credit for the window holding when you try to bash it with your foot. You don't get any credit for that. And the defendant doesn't get any credit for that.
But you can't
so
get
that's
jail
where
time.
The assault on Emma applies, not through direct physical contact, but through the apparent intent and ability to cause harm if not prevented. If not prevented by the door, and if not prevented by Alyssa telling him to get out of there, and Emma subsequently taking out her phone. Those are the things that stopped this from getting much, much worse than it already was. So, assault in the 4th degree is proven beyond a reasonable doubt for Emma. So, now we go on to Alyssa. Alyssa is a much more straightforward case. It's the first definition of assault. An assault is an intentional touching or striking of another person that is harmful or offensive, regardless of whether any physical injury is done to the person. A touching or striking is offensive if the touching or striking would offend an ordinary person who is not unduly sensitive.
It's offensive if it's offensive. I get it now. Looking for his water. When we go to Verdict Watch, we do have a new song to debut for you. It was a request. It's a new style. Not country, just for those who are saying enough of the
Publishing
country.
States Exhibit number 8, 7, and 6 to the jury one last time.
One last time. I love this prosecutor. If you can remember the first time he was up there, he struggled so badly. He's come a long way really quickly.
The assault on Alyssa. Alyssa is the passenger. We've talked about this briefly with Emma, but Alyssa sees what's happening on Emma's side of the door, and she's scared. She's scared for Emma. So she gets out to confront him, to get him to leave, to get him to get in his car and get out of there. So she exits her vehicle and she starts heading this way, and then a physical altercation ensues. So the question of what happened here is whether or not the assault occurred. And we have some accounts. Alyssa and Emma's statements is fairly consistent. I asked Alyssa, hey, you were in the thick of it.
Did you say spoketh?
Do you think you could give 100% play-by-play as to what's happening while all of that was happening? She said, some of it is vivid. Some of it she can remember. Some of it she can't. And you can blame her. She's grappling with a adult male who is a foot to 2 feet taller than she is. This incident was unpleasant for Alyssa, to say the least. So Alyssa does remember some of it, though. And what she remembers is supported by Emma. And some of it is also supported by Jean Wright, who doesn't know anyone in this case and has no dog in this fight whatsoever. So both Alyssa and Emma said that the defendant struck Alyssa in the face. Alyssa said that it happened once. Emma said that it happened twice. However, both of them said that she was struck in the face. Both of them also said that the defendant kicked her. Both of them said that he kicked. The defendant said in his version of events that he put his foot out towards the victim, towards Alyssa, to keep her away. So he does not say that he kicked Alyssa. He does not say he had any physical contact with Alyssa, but he does say that he lifted his leg to, just keep her back a bit. So we have the kick is supported by Alyssa and Emma again. And then we have the lifting her up off the ground. Again, it kind of illustrates the size difference here. Jean Wright described it as someone striking up against an iceberg. Like it lifted her up in the air. She jokingly said that she went from a 4'2" person to a 6' person, which just caused me to comment. So you mean like 2 feet off the ground? She said, okay, not quite that much, but she's saying that she lifted her up off the ground. And this is supported by Emma's statement and by Alyssa's statement. What was the defendant's version of events? The defendant said no physical contact. All I did was keep her away with the foot, and that's all that happened. There was no physical contact at all. That is flatly contradicted by Alyssa and Emma and by an unbiased witness who was driving by and seeing what's happening. So Jean Wright says that she believed that there wasn't anything other than that. There wasn't anything other than that. And she said that she had an okay view. She said that she could not see the truck. She said she couldn't see the back of the truck. She couldn't see the front of the sedan. And she said she could see a little bit in between the two of them. She said that she could see around the chest area. So what would be the most noticeable thing to happen in that situation that someone would see from that distance? How about someone getting lifted up in the air? And she said she wasn't able to clearly see the head. She said she could see it maybe up to here. So the long story short is that Jean Wright's version of events does not contradict what Alyssa and Emma said, because she's behind another vehicle. And again, Alyssa and Emma are both fairly small individuals. So she's not able to see the complete picture. But the picture she is able to see is fully consistent with what Emma and Alyssa said. So we have evidence here. We have evidence in the marks in the face. Speaking of, I'll go ahead and take the exhibit back. Thank you.
Prosecutor is super excited. I think he feels like he's got this one on lock.
So we have the marks on the face. We have an unbiased witness. What they're saying does support part of the narrative that Emma and Alyssa provide. I asked Alyssa, and I said, I don't know how to say this without being awkward, but does your face normally look like that? And she said, well, it can swell up from time to time. And defense counsel was like, okay, what could cause that? And she said, well, spicy food, I guess, could cause it. She said she wasn't sure if stress could cause it or not. I don't know if she's self-aware enough to know that about herself or not. But only two things happened that day that could have caused that swelling on her face.
Spicy food. And
getting punched in the face and the stress of getting punched in the face. Both of those were caused by the defendant, and both of those are seen in the photograph.
Apparently grandma doesn't make spicy food.
We have marks on the victim's face. You'll also be handed
if the prosecutor loses this case.
Very briefly,
He's only got himself to blame. Defense did nothing.
Me going a little bit out, just very briefly. There were also physical photographs taken of the window of Emma's car. There are footprints on the window. Law enforcement officers said they saw 2 footprints. That will go back with you into the jury room to decide for yourself what you see in that photograph. The question is, how could footprints get there but for this situation? And again, it's physical evidence that supports Emma's side of the story and directly contradicts the defendant's side of the story, who said he did not strike the window. So, again,
he actually said he did kick the window.
That's it. You have reckless driving, assault against Emma, assault against Alyssa. When looking at reckless driving, focus on the defendant's driving patterns as described by Gene Wright, as well as Alyssa, as well as Emma. Focus on the driving pattern that was described and whether or not that was reckless in isolation from other events, whether that was a reckless behavior. Emma, focus in on the statements that were given as well as the photographs. Again, an intentional touching is not required for Emma. And for Alyssa, I just provided you the photographs for that as well as his statement. So now that every element has been met beyond a reasonable doubt, if you believe that is the case, then the question of self-defense comes in. And very briefly, if you go to page number 14 of the jury instructions, and we're also going to talk about number 15. So 14 and 15 are the primary ways that physical contact in this case would have potentially been lawful. Self-defense is a defense to an assault that did occur. So physical contact happened. So the question is, was that justified? The point is that you can be in a situation where it could be justified for you to punch someone, to push someone, to do something to protect yourself. So the question is, did the defendant properly exercise self-defense? So this is really important to look at. On number 14 will be the first one we look at. No person may, by any intentional act reasonably likely to provoke a belligerent response, create a necessity for acting in self-defense or defense of another and thereupon use, offer or attempt to use force upon or toward another person. So we're going to stop there for a second. Any intentional act reasonably likely to provoke a belligerent response. How about brake checking someone, getting out of your vehicle, going to the vehicle next to you, and slamming on the driver's side window with your foot multiple times? How about that? There's evidence of that. There's testimony to substantiate that, and there's physical evidence of that. So right there, the defendant is not allowed to use self-defense because he caused the fight. He caused the altercation. He's the one that caused this to get physical. Alyssa would not have gotten out of her vehicle had he not walked up to that window and struck it multiple times with his foot. So right there. And then the other, creating a necessity for acting in self-defense. I would say that it's arguable whether or not there was any necessity at all in this case for physical contact, even after striking the window. But even if it did create a necessity, that provocation created the necessity. So right there, the defendant is barred from using self-defense in this scenario. Now, onto instruction number 15. Instruction number 15 is the bounds of self-defense. So if you satisfy 14, meaning if you weren't the first aggressor, which in this case he was, but if he was not the first aggressor, then there's limits as to what self-defense you can employ. It has to be reasonable reaction. It has to be a reasonable reaction. Instruction number 15, it is a defense to a charge of assault in the fourth degree that the force used was lawful as defined in this instruction. The use of force upon or toward the person of another is lawful when used by a person who reasonably believes that he is about to be injured, or by someone lawfully aiding a person who he reasonably believes is about to be injured, in preventing or attempting to prevent an offense against the person, and when the force is not more than is necessary. So the question is, Was he in reasonable danger of being injured? There's no evidence whatsoever that Alyssa had a weapon in this case. What's here is that someone who is much smaller than him got out of the vehicle and told him to leave. That's what the evidence here supports. And then going on to the next portion, it says the use of force upon or toward the person of another is lawful when used in preventing or attempting to prevent a malicious trespass or malicious interference with real or personal property, lawful in the person's possession, and when the force is not more than is necessary. Not more than is necessary. Let's take the defendant at his word here. He said that someone threw a can at his truck. He said, "Don't throw shit at my truck." And he said that after he knew he was on camera, because Gene Wright knew he was on camera. Emma was holding it out so that Alyssa knew he was on camera. So he knew he was on camera when he said that. But let's just say that a can was thrown at his truck. Is it more than necessary to get out of your truck, approach another vehicle, strike the window, and then grapple with the person who gets out and tells you to leave? No. There are so many reasons that self-defense does not apply here. But going on to the next one, the person using the force may employ such force and means as reasonably prudent person would use under the same or similar conditions as they appeared to the person, taking into consideration all of the facts and circumstances known to the person at the time of the incident. What did he know immediately after Alyssa got out of her vehicle? What did he know immediately? He knew this person is much, much smaller than me. That was an instant click in his head. And he believed that it was necessary to punch her multiple times in the face, to kick her, to pick her up, and to slam her into the hood of her vehicle before leaving. Alyssa doesn't want this fight to happen. She doesn't want this to last any longer than it does. I specifically asked her, hey, did you ever go after the guy? Did you ever want this to continue? Did you do something to make it happen as long as possible? And she sat there was like, no, of course not.
No.
So, and when he decides to leave, when it's clear in the video that he's leaving, they don't go after him. They don't go after him. They take a video of his plate because they want to report it to the authorities. Then they get in their car and they continue on to their grandma's house. And in this situation, both of them are heading down the same one-lane road, and both Emma and Alyssa said they did not deviate from the direction to their grandmother's house. So self-defense does not apply here. So I'd encourage you to look through all the elements of the crime, to look through all the bases of self-defense that we discussed here today.
Big finish here. Big finish.
The question at the end of the day here is, are you convinced? Did the state convince you? Did the testimony, the physical evidence, did the video, did it convince you?
Objection, misstatement of the law.
Overruled.
That's what it means. That's all it means. If you go again back to, I believe it was instruction number 3, it says abiding belief. It's a belief that sticks around. This is my opinion, and it's staying there. An abiding belief after you consider all of the evidence presented. Each of the elements have been proven here. So the state is asking you as a jury to do your duty and to find the defendant guilty of reckless driving, assault in the 4th degree against Emma Hammersley, and assault in the 4th degree against Alyssa Compost. Thank you for your time today.
Thank you, Mr. Holcomb.
Is he going to get a second bite of the apple?
Please give your attention to Mr. Pizderka for his closing argument on behalf of Mr. Walpole. Mr. Pizderka?
See how Mr. Pizderka goes.
Good afternoon again, members of the jury. And I apologize.
Our new song is such a good response to the high energy.
And would it be possible to save some time for rebuttal?
What? Yes.
Thank you.
He asks about that now. Can we have some rebuttal time? Says, take your stinking laptop. I've got my own. A lot of confidence plugging in new equipment, hoping it works.
Your Honor, briefly, may I approach?
Yes, with Mr. Pizderka too.
Before it's published to the jury.
So this is already in evidence.
Okay, so could counsel approach, please?
He's like, turn it off. They're going to see it. They're going to see it. Turn it off.
So this is a copy of which.
So just not right. It's not. This is not. This is just a. It's not. It's, right. This is clarifying parts of that. So demonstrated. This is the exhibit that I've changed the exhibit. Just highlighting parts.
Okay, so just okay. So members of the jury, the clerk is going to take you back into the jury room. We're going to do some things on the record here, and then you'll be brought back out to hear closing argument from Mr. Pizurka.
Okay, the state has objected to the PowerPoint that defense wants to show the jury. Why
don't you go back to your microphones? And then
every fiber of my being wants to sustain that objection because A, it is a PowerPoint, and B, it is a PowerPoint.
My client's requesting to use the restroom.
Yeah, you can do that.
We have a runner.
Should we wait till he gets back?
I think we can argue the point.
Okay.
Go ahead. So, Mr. Holcomb, I'll hear from you first.
So, I guess part of this can be, I'm gonna try to be quiet because in the past, jury members have said they've been able to hear my voice while I'm out here during these discussions.
Okay.
So,
why is that?
Perhaps Pazurka could clarify, and that may cure the issue that I have. During the cross-examination of the trooper, Pazurka asked if there was an alternate route for that Emma and Alyssa could have taken, or something about a U-turn, and defense left it at that. And there was no demonstration that like on a map that was the case, or so if this is an alternate route or something, that's the problem I would have. If this is just a circling of the area, then that's fine. I just saw from my table the red markings and thought that was Google.
So let's have Mr. Pazurka explain what he did, and then you can see if you object to it. Okay. Yeah. So go ahead, Mr. Pazurka.
Yes, I've drawn over. I've not have changed the exhibit in any way. I've merely made a blue arrow pointing to the exit ramp, or like the interchange that is been testified to is where the altercation happened. And then I've made what is intended to be a red bracket, bracketing Mud Bay Road, which is purely just to notate the
just lost out on this one.
The road that the witnesses testified to driving down after leaving the highway. And to Mr. Holcomb's point, it is not meant to indicate an alternate route or anything like that. It is merely just to highlight the road that was discussed by Ms. Hammersley and Ms. Campos, as well as what that question I did ask of the trooper.
So I guess what's your point? What's the point?
Doesn't matter.
Point of the.
I mean, yeah. Why is that relevant to what we're doing here?
It's relevant and goes to my arguments regarding the credibility of the witnesses. We've heard 4 different versions of events, and I
mean that's specific. What
both Ms. Hammersley and Ms. Campos testified that they continued down Mud Bay Road, right, and that they both, after doing so, saw the defendant's vehicle again. Ms. Wright testified that she witnessed both the truck and the sedan return to the highway going northbound. And so the intent is to
impeach them,
just demonstrate that they essentially are going in opposite. If Ms. Campos and Ms. It goes to the credibility of who the jury should believe by showing the physical directions of the alleged parties are testifying to having gone, and the point of the bracket, I suppose, and if that's the issue, I can remove that, is to show that there is no further the main thoroughfare connecting that section of until you get to Delphi Road, essentially. and also that it crosses a body of water.
Okay. Mr. Holcomb.
So, firstly, Your Honor, I have no objection to the blue arrow, as I believe that that's just pointing to the spot where the altercation happened. So I have no objection to the blue arrow. The bracket, however, I'm uncomfortable with because,
we don't like brackets,
or I'm objecting to, because while witnesses provided oral testimony, they did not at any point point to a map. A map wasn't shown to them telling them, hey, which direction did you take on this map? I believe that that's just facts, not in evidence at this point. Had that been done, where either myself or Paz Durka had asked them what route they took on that map leaving the scene, I wouldn't have a problem with it. But I believe that doing that in this incident is problematic.
We're in the Olympia
Your Honor,
area,
if I could
Thurston County.
that this map has been stipulated to. It is in evidence. The map itself is evidence that the jury is allowed to review, and the trooper did testify, as well as every witness, that that they were driving on Mud Bay Road at some point.
Right.
Just allow it.
And
Let's
to
move
just
on.
show a map in evidence to the jury.
You can show the map. You can make whatever argument you wish to make out of the map. You can leave the arrow, take out the bracket, and then if you want to go on the map and use a pointer and say this is
draw brackets on the TV screen. Google Maps is the court certified cartographer.
Yeah, you can do that if you wish. I guess we'll handle it that way, and you can make it whatever you want out of the testimony.
The guy sitting back there is either a friend or a relative of the defendant.
And make out of the test. You could use that map that way. Just and you have it up there, and you can reference that and make whatever argument you wish to make.
So just so I clearly understand, bracket leaves, blue arrow stays, but you can reference the map.
Yeah, I mean, he's right. He's admitted into evidence, and I'm not.
Yes.
I would let him keep the bracket. Or if I were the defense attorney, I would make an argument that basically, went up there into the screen and said, imagine there are brackets right here. So you can
practice pointer. If, in the future, if you want to make that point and do those things, get it admitted and then make those marks through Wista's testimony and say, what about here and here? And then you can make all the marks you want on it. But after it's been admitted and all the witness testimony's gone, then, I'm really adverse to amending it in any way. But again, when the testimony's going on, you can do whatever marks you feel is appropriate.
This isn't a courtroom open to the public.
I'm sorry?
I said that was not my understanding of the proper procedure of this kind of argument, but I will take that into consideration. Yeah, thank you.
Well, it's my procedure.
There we go. We got grounds for appeal. Preserve it for the record. I'm going to appeal.
And I think it's the procedure of any judge, at least in district court, that if you are going to make changes on it, marks, you get permission first.
I would say, hey, look, brackets are gone.
Yeah, I'm just pointing out the interchange.
Yeah, that's fine. Yeah, you're good.
Wow. These two guys.
Let me know when that's up and you're ready to bring the jury back.
Please, sir, may I have permission to punctuate? Teresa, that's funny. He's been a much better prosecutor now that his dad has given him the stamp of approval on his new job.
Are you going to be using that screen for other things?
No.
Just that.
Yeah.
Just the brackets.
Okay. You can
bring the jury.
If you will bring the jury.
This is a funny courtroom. The carpet is a little trippy. It does seem like a hotel conference room. But it's got to be one of my favorite courtrooms. Prosecutor is going to has about the same time usually. The judge said no time limits. Oh, everyone's standing up. Jury's coming in. And then or the defense has that. Prosecutor does have rebuttal.
And again, members of the jury, give your attention to Mr. Berserk for the closing argument on behalf of Mr. Roswall.
Good afternoon again. Like a small ship hitting an iceberg. A ship that was intentionally driven with full knowledge of what it was doing and where it was going. What you have heard today is 4 separate versions of events. You've heard Ms. Hammersley's version, Ms. Campos's version, Ms. Wright's version, and you have heard the defendant's version based off the statements he gave to the officer days after the event. The prosecution in this case would like to cherry pick what parts of the evidence you should believe. Which parts of certain witnesses' testimony is accurate, but ignore other parts of their testimony. It is your job to determine which version and/or versions and/or testimony is credible. But I would encourage you to review the versions of events in totality, the witnesses' testimony as a whole, rather than just parts separate from the other parts. To this point, the prosecution would like you to believe that Ms. Wright was accurate in her observations of the driving behavior of the defendant and parts of the altercation, but does not want you to believe other things that she may have testified to, such as how it was clear that Mr. Roswall was acting in self-defense, or how that she maintained that she never lost sight of Ms. Campos once she exited the vehicle. And I want to highlight some of the other parts of the testimonies from all witnesses that are at odds with each other. Because at the end of the day, it is your job to determine what parts of the testimony and the evidence you find most credible. And I would put it to you that Ms. Hammersley's testimony is most at odds with the 3 others' version of events. Specifically, when describing the driving behavior of both her and Mr. Roswall when approaching the exit. She maintains that she had to brake and slow down when she went around the curve, that she did not speed up to catch up with him, that he in fact slowed down to jockey with her, when in fact both Ms. Campos and Ms. Wright's testimony contradict this. Ms. Wright indicated that when they passed her, they were both going the same speed and were communicating, as she said, because of how close they were. Ms. Campos also testified that Emma maintained speed to keep up at least the same rate of speed as Mr. Roswall when approaching the exit. Ms. Hammersley also indicated that Mr. Roswall cut her off when exiting onto the exit from the left lane across all lanes. However, Ms. Wright and Ms. Campos both testified that both vehicles were in the right lane before exiting. Ms. Hammersley also testified that Mr. Roswell got out of his truck immediately, before the truck had even had time to stop. However, Ms. Campos testified that there was at least 2 to 3 seconds before he did so. And while that may seem insignificant, Ms. Wright testified that this whole interaction took maybe 30 to 45 seconds. 2 to 3 seconds is not insignificant when assessing how quickly or with what sort of intent someone left their vehicle. Indeed, the prosecution understands that it would seem to understand that that their case is on shaky ground if you were to believe Ms. Wright. However, Mr. Holcomb did concede in his closing arguments just a minute ago that Ms. Campos confronted my client. He also conceded that Ms. Wright is an unbiased witness. And so that brings me to the altercation in question. I would point out that the one convenient thing that the prosecution did not ask you to consider in his closing is the video. The video that does not support Ms. Campos or Ms. Hammersley's version of events. And to this, I want to put it to you that part of considering someone's credibility is also considering their motivations. One of the jurors in voir dire yesterday talked about assuming that a witness wants the best version of themselves presented. And so when reviewing the altercation, both Ms. Campos and Ms. Hammersley were adamant that Mr. Roswell was the aggressor and that he advanced on her. Ms. Hammersley testified that his attacks on her made her retreat multiple times, that he continued to advance on her. Ms. Campos testified to largely the same, and they both testified that that she was pushed towards the vehicles. As the video shows, they are not near the vehicles when it starts. They are across. They are the other side of the exit lane from the vehicles. A position they would have to be in only if Mr. Roswell had gone backwards or turned around and walked over there, or if Ms. Campos had shoved or attempted to shove him in that direction. And this seems to support Ms. Wright's testimony. And as the prosecution pointed out, she was unbiased in this situation. Her motivation did not have a dog in the fight. Her motivation should be considered less complicated than the other testimony you heard today. She testified that she saw Ms. Campos get out of the vehicle, run around the car, and charge towards Mr. Roswell. It was clear to her that he was acting in self-defense. She said so. And regardless of the size discrepancy between the two, the requirement for self-defense does not require me to prove to you that Mr. Roswell could not have been harmed by Ms. Campos. Only that he believed that in order to prevent an offense of his person, that force was necessary. However, it cannot be more force than is necessary.
I've never seen
a
self-defense case.
I once again turn to the video in which
testify.
We see Mr. Roswell shove Ms. Campos away and walk back to his truck. The prosecution would like you to believe that he was the aggressor and instigator, and what he intended to do was harm these two women. And to that I ask, is that a reasonable thing to think? Is there perhaps a more reasonable explanation? given all of the testimony we heard? Is it more reasonable that this was the end or middle, depending on how you would describe it, of a road rage incident in which both sides were angry, upset, their adrenaline was pumping, they both believed they were in the right? Mr. Roswall testified to the police that he believes they threw something at his vehicle, and he got out in anger and testified to kicking their car. He did not testify to striking Ms. Campos. The prosecution just told you that he denied striking the vehicle, which is not what he reported to the officer. And in fact, Ms. Hammersley seems to have understood what his intent was, because when asked whether he was trying to damage her car, she said yes. And this brings me to the point that fear is not proof of intent. Ms. Campos and Ms. Hammersley may have been afraid because of the situation, and Mr. Roswall might have done something irresponsible or something we wouldn't condone. However, his intent, based off of the testimony, based off of his statements to the police, based off of what we see in the video in which he yells at them to stop throwing things at his car, he felt that his car had been damaged. He was trying to damage theirs in return.
Eye for an eye. Good.
There is no evidence that he intended anything other than that.
Yes, 57%. No, 42%.
He did not make threats. There's been no testimony or statements by any witness that he threatened to hurt them, that he wanted to hurt them. There has been testimony that both sides were cussing at one another, that obscenities may have been exchanged. But as the jury instructions will tell you, I apologize, I believe jury instruction number 14, words alone are not enough to provoke or commence a fight. So although the prosecution wants you to believe that Mr. Roswall was the instigator of the fight, there is nothing in the testimony or evidence you heard today that shows that to be true. And that brings me back to the driving that we have heard about. When considering whether Mr. Roswall drove recklessly, it is not enough to just ignore the other vehicle's behavior, as the prosecution would want you to do. It is true that it doesn't matter whether they were also driving recklessly, but it does matter what Mr. Roswall was perceiving and responding to, and whether his actions were reckless or irresponsible in reaction to them. Ms. Wright testified. Mr. Roswall told the police that he was trying to get away from them. You heard zero evidence today that Mr. Roswall ever pursued or followed their vehicle. He tried to pass them, and after he did so, he continued to try to get away from them, including when he swerved off onto the exit, something Ms. Wright interpreted as his attempt without using a blinker to get away from them. In fact, Ms. Wright herself testified that she saw Mr. Roswell's truck and their vehicle return to the highway, going back the opposite direction after she drove away. And that once again brings me back to the issue of credibility and the versions of events you heard and how they are at odds with one another, because both Ms. Hammersley and Ms. Campos testified that they, after the altercation ended and they returned to the road to go to Ms. Hammersley's grandparents, saw the defendant's truck again on the road. They both testified that they continued straight after he turned left back onto the highway. Ms. Wright also testified that she did not see either vehicle pass her as she was parked on the highway calling 911. And sorry, return to the map very briefly. indicate that if someone goes back north on 101, in order to get back to Mud Bay Road, both Ms. Campbell and Ms. Hammersley testified to seeing him again, Mr. Roswell again. There is no easy way to do that without you turning on the highway and coming back to his exit. There is no major thoroughfare that connects Mud Bay Road to any other. It crosses a body of water. Ms. Hammersley and Ms. Campos and the prosecution would like you to believe that somehow, with no explanation, Mr. Roswell, within a few minutes, returned to Mud Bay Road for whatever reason. Ms. Wright, however, testified that she saw both vehicles return to the highway going northbound, which would once again support Mr. Roswell's intent to escape a pursuing vehicle, one that continued to pursue them after the altercation that we have heard about. So I do want to return to Ms. Wright because I do think it's relevant. And as the prosecution noted, an unbiased witness should not be disregarded for the parts of the testimony that fit your argument or don't fit your argument. I think it is appropriate to question the motives of Ms. Hammersley and Ms. Campos and the version of events they want to have you believe. The version of events they may misremember. Ms. Hammersley, in multiple times in questioning, stated that this event happened months and months ago in February, so long ago that she may or may not have said different things because she couldn't remember. But then when asked by the prosecution whether there were certain things she remembered, she stated she remembered the assault vividly. And I don't think that you can have both things be true without having some sort of motive as to why you are allowed, why you think it is reasonable to not remember some of the things that you may or may not have said while vividly remembering what someone else did to you. The prosecution has said many times during the course of this trial, talked about many times about abiding belief. Have I convinced you? I believe the more important question is, has he proven, has he made sufficient argument, shown you sufficient evidence that any reasonable doubt you have has been quashed, has been answered? Because it is his job to prove that my client is guilty beyond a reasonable doubt. It is not my job to prove that he is innocent. And so, while prosecution may want you to focus on what your abiding belief is, he is conveniently
careful
trying to tell you that you should not have any reasonable doubts. When in fact, in this case, we have 4 different versions of events. I would argue 3 of those versions of events have been and may have been presented by people who have valid and understandable motives to make themselves look better than how they may have behaved on that evening in February. However, we have a 4th witness who is unbiased. And I believe you should take into consideration all of her testimony, not just some of it, not just the parts of it that support Ms. Campbell and Ms. Hammersley's version of events.
I think he's doing okay here. I think he's
Your job is to determine whether the prosecutor met his burden to prove Mr. Roswell guilty beyond a reasonable doubt. It is not your job to figure out with 100% certainty what happened that night.
Good point.
But I do want to leave you with a final comment from Miss Wright when asked to clarify what she perceived happened during the physical altercation. She said, and I quote, "He stopped it." Mr. Roswall walked back to his truck and drove away. Thank you.
And members of the jury, prosecutors carry a burden of proof in this case, and as such, they're entitled to rebuttal arguments. So for one last time, would you give your attention to Mr. Holcomb for his rebuttal argument?
This should be a response to argument here. Let's see what issues the prosecutor took issue with.
So, first off, thankfully he did end the fight because Emma and Alyssa could not. They're not going to drive through a truck. They're not going to drive through a person that's approaching them. So the question isn't who ended it, because they physically could not. The question is who started it and who continued it and who caused it to escalate. And also, I found it interesting that defense said that I'm asking you to disregard the video. When I played you the video, I may have missed it, but defense counsel did not. He also said that I'm really focused on abiding belief for some reason. Well, the reason is because it's in jury instruction number 3, which has been explicitly provided to the jury as to how they are to judge the case, which again, conveniently, was not referenced by defense. So first off, let's play that video, because defense said that, look, you really need to focus on the video here, because that's really important to focus on. So let's focus on that video and actually
or on.
Play it briefly.
This might have been a tactic by the defense to get him to do this with the audio on, because it sure makes the victim look like she's hooting and hollering. Just the highlights. It's like 11 seconds long. There's very little to it. John, happy birthday. Welcome back.
First off, it's only 11 seconds, so I'm going to play it unmuted just so that we have the full video. I'll just go through it really quickly.
Content warning.
Volume.
Get your fucking hands off of her! Get off our truck. Good luck, nigga!
All right, so.
All right.
Let's focus on that video. Stop there. Directly contradicts the defendant's version of events. We're less than a second into the video. Instant contradiction. There's physical contact there. Is he using his foot here to create distance? No. Instant physical contact here.
Get your hands off of her!
Where is his truck? Is it on the shoulder to tell him to pass by? Is it on the shoulder? No, it's in the middle of the lane.
Get your hands off of her!
And how do we know that he's not in the shoulder?
Right now! Get your fucking hands off of her!
Because a truck on the other side uses the shoulder. You can actually see his tire. It's not even on the. It's not even crossed into the shoulder. Again, defense counsel said that I want you to focus on specific pieces of evidence and disregard others. It's literally the job of the jury in the first instruction that I read off, where it says you are the sole judges of the credibility of each of the witnesses. So your job is to weigh the different evidence that's in front of you, because of course some of it's conflicting. So you have to decide what's true and what's not from the evidence and whether that's sufficient to meet each of the elements. So, but defense counsel also talked about the fear of Emma being in the car, and fear isn't enough. It's not enough for her to be afraid. That's not enough. There has to be proving intent here. You have to prove the intent. So let's look at assault. Let's look at the definition of assault.
And you will see there is explicit language in there that talks about the intent
To inflict bodily injury, specifically when it relates to Emma. There has to be the intent to do it and the apparent ability. So let's look at intent, which defense conveniently did not direct you to, number 12. Number 12 specifically talks about intent, as well as number 13. Number 12, a person acts with intent or intentionality when acting with the objective or purpose to accomplish a result that constitutes a crime. So, when it comes to intent, how are we to decide intent? None of us are in the defendant's head. So, we can't tap into his brain and be like, okay, what was the intent? How do we establish intent? You do it by their actions. What did they know at the time and what did they do at the time? Go to instruction number 13. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result when he or she is aware of that fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. When acting knowingly as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally as to that fact. So we have the defendant's actions. We have what the defendant knew at the time. What does he know at the time? There's a car parked behind him that he has had an altercation with on the road. He gets out of his car, walks up to the side, and slams the side heavily with his foot against the window with her sitting in the car. So what is that going to cause? What is that going to cause? It's going to cause fear. It's going to cause someone to apprehend that you are coming at them with the intent to do harm to them. Not like, as we said earlier during jury selection, I threw the vase at you and I wanted to scare you. I wanted to cause you to see that I was coming at you with the intent to hurt you and the ability to do it. So that's clearly here. So, yeah, this is a case where you're given two accounts. You're given accounts by victims in this case, by the defendant, who's 1 second into the video, we know that what he said is not true. 1 second in. And then 2 or 3, 4 seconds in, we know what he said is not true. Directly contradicted by the video right in front of you. You don't even have to take anyone's word for it. It's right there. So we have the defendant's account, which is also undermined by Jean Wright, who defense says is a very reliable witness, which she is. She doesn't have a dog in this fight, but her view is limited. So the state's perspective is because your view is limited, you're able to see some things, but not all things. She said that you lifted her up off the ground like a ship hitting an iceberg. So again, defense is telling you, yeah, you need to believe Jean Wright. Yeah, she said that she lifted her up off the ground. Yeah, you should believe that. That directly contradicts the defendant's version of events here. So we have two accounts of what happened here. One is supported by the evidence. One is directly contradicted by the evidence. That is both unbiased in the form of a video and in someone who is passing by. So again, all of the elements are met here. I walked you through all of the elements. And because all of those elements have been met beyond a reasonable doubt, I ask you to do your duty as the jury and to find the defendant guilty of the crimes that are alleged here. The crimes of reckless driving, the behavior that we discussed earlier and that was testified to in closing on the road, again, focusing on what the defendant was doing. Let's just buy the defendant's argument that the other driver was acting aggressively. Was that a reckless response? Was that a proportional? Was that something that a reasonable person would do, even if the other person was driving recklessly? Driving next to them as close as you can, passing back and forth to them, slamming on your brakes, swerving into their lane. Even if we bought those version of events, that's still driving recklessly. And again, for assaults, there's evidence for the assaults that we've gone over and reasonable doubt. As defense stated, it is not your job to figure out with 100% certainty what happened that day. That's not the task of the jury here. The task of the jury is, did the defendant's actions amount to the elements of each of the crimes? And if the answer is yes, then the answer is If that is true, then the answer is guilty of each of those crimes, if those elements are met. Thank you for being here today. Again, I appreciate your dedication to the process. And again, I ask you to find the defendant guilty of all 3 charges. Thank you.
All right. The jury is going to start.
Members of the jury, you will now be taken back to the jury room where you will begin your deliberations.
We're going to start our timer because we're going to count how long they deliberate. And I think they're going to kill our feed as well. Depends what happens here. Let's see. Cancel. Stopwatch. Start. There we go. I promised you a song, which we're going to play here in just a minute. Let's see if they have anything to discuss. They're probably going to talk really quickly about evidence. He's quickly ejecting the thumb drive so that can go back with him because he just played the video. Eject, pull the thumb drive. It's good. It's good. Don't corrupt it. Whatever you do, don't corrupt it. Okay, there you go. We're good. Hand that to them. Boom. Good, good. Whew. They almost didn't get the video. That would have been terrible. I think they're going to watch that a few times with the volume turned all the way up. And they're going to be asking, why is nobody talking about the elephant in the room right now? All right. Take your time. Door closed.
If you leave, just make sure Amy or Candace knows how to get a hold of you.
Yep.
Okay, so we have officially started verdict watch in this case. Shouldn't be a long one.
Your Honor, can I just clarify, just since it is 3 o'clock, at what time do you...
Hang on a second, I'm about to sneeze.
You're fine.
1 second.
Maybe.
Judge has a tickle in the nose happening.
Sorry.
Is there a set time or is it?
There's not. We're just going to see how it goes. We'll just kind of see where we're at. Okay. And then, yeah, we'll see how it goes.
Okay. So,
and we're going to go off the record here in just a minute. I'll keep the audio on in case we hear anything. But I did promise you a song. Tonight we have a podcast. Thomas and I will be live at 8 p.m. on this channel with a podcast. It is the Not Relevant podcast. If you guys sometimes get a little weighed down with the usual, murder trials and everything else that we cover day in and day out, this is your fix for that. It's a lighthearted, funny look at the world today. Mostly news. It's still a Pickles, Not Politics thing. So you can expect very, very little in that regard. As a matter of fact, I would set your expectations low in general. But we have a lot of fun, and please join us. It's going to be a lot of fun. Let's see. I've got a song. I had a request. By special request, somebody said, and it stuck with me. They said, "Gray is the new green." So we have this slow, and it is slow because the prosecutor was so fast and animated. We have a slow song, electronic pop. Gray is the new green. It's a laid back sort of song. Here we go. Hope you enjoy it.
In the land of pixels, here we meet. Gray's the color of our simple seats. No flashy lights, no fancy scheme. It's low-key love in a cyber dream. Slow mode life, we're taking it easy. Calm in the chat, everything looks breezy. No golden throne, no crown on screen. Yet still I feel like royalty unseen. Gray is the new green, don't you know? In the digital glow, we take it slow. No need for emojis or special code. We're riding high on this mellow road. Gifted green lights up the scene. ticket to a world unseen. But here in gray, we find our creed. No extra flair, just what we need. No temp seats, no quick retreats, just hanging out in these cyber streets. Gray dust clouds, our silent beam, a hidden treasure in the live stream. Gray is the new green, don't you know? In the digital glow, we take it slow. No need for emojis or special code. We're riding high on this mellow road.
There we go. Beautiful little song. Gray is the New Green. We'll put that on the B side of the album. It is available over on our Suno playlist. Once more, AI with just a few prompts has been able to capture the spirit of chat entirely. Thank you all, and as a way to get somebody out of gray and into green, Bug Dugger gifted membership. Congratulations. Also, Queen Olive gifted membership. Thank you both for that. That's very generous of you. It's a nice mellow song. And you guys requested no more country, or at least maybe a break from the country. So we used a different method that way. All right. Still live stream going from court. No audio right now. Prosecutor is pacing a little bit. Defense is sitting tight. Well, while we were waiting, hang on.
Great job for your first trial. It was a Myers trial. So
I know.
Great job. Great job keeping up with everything.
I know. Thank you.
the first trial was a clerk, not the defense. That's what we were just hearing there. Ooh, record scratch. So I was looking at my candle, and I realized on the back of my candle, by candle, I'm talking about the one that stinks, this Festivus candle, which will be lighted on Monday's stream. Festivus, for the rest of us, smells like disappointment infused with grievances, made with genuine feats of strength. Directions, are you an idiot? Uses, serenity now, and it is tinsel-free. I noticed on the back there is also a label. It doesn't say that this candle is foul-smelling, but it is. On the back, it said something, and I had to zoom in with my phone to read the fine print. And it said, says this, let's see. It says, genuine fire starter. I will burn down your house. Don't burn me and leave me like Miss Barrymore would. Keep wicks trimmed to 1/4 inch and only light me for 4 hours at a time unless you want to see some hot firefighters. There you go. So it does have some instructions and some warnings. So, like, whoa. So, I have no desire to see any hot firefighters. So, apparently 3 hours and 59 minutes is my limit with this candle, if I can make it that long. 4.5 hours later, boom. And bring your camera, and you have yourself a calendar, right? All right, they just send the candle to me. Everyone's like, when you're done with the candle, can I have it? No. All right. I don't want to see the hot firefighters, period. No, I don't. That's a no for me. My town has volunteer firefighters, by the way. Great people. Okay, so now we're at the point in the show where we have to constantly refresh because whenever the jury does come back with a verdict, they will not notify us. They are just going to go live, and it will start with, and the jury, you've reached a verdict. That's how it goes. What is your vote on the verdict? Josh, I also believe, here are the issues. The defendant, Joel is his name. We're going to talk a little bit if he gets convicted about some other things, but the defendant has some big issues against him. First of all, there is a video of him in front of them coming back to the car. There is apparently, allegedly, his boot print multiple times on the girl's window. And there's a physical altercation going on with him. I think it went too far. I think he did some things he shouldn't. Now, if he had just pulled over and said, hey, what's the problem? Why are you throwing stuff in my car? Okay, that's not smart, first of all. Generally, confronting people who are already doing something bad is not smart. They already don't obey the laws. They're not following the rules. They might break some more involving hurting you. But not smart, but I could understand that a little more. It's the kicking the door, which we have like pictures of. That's a problem. That's a problem. You could do a whole new stream with the firefighters. I'm just worried they'd cut the power to my house and the live stream would go down. Uncle's a firefighter, married a policewoman. Guess how they met? Was it a car accident? Where do you get a firefighter and a policeman at the same call? But your home's made of wood and plaster. Yeah. Now it's made of less plaster because we've completely demolished 2 walls. The kids ripped out a big, no, it's a 100-year-old cabinet with, I think it has like mercury glass. It's that glass that has like silver on the back. I think it's mercury glass, which is probably poisonous. But it's like one-way glass. It's like a glass that's been turned into a mirror with some chemicals on the back. Pretty sure it's deadly. Poisonous. Anyway, they ripped that out. We've cut the pipes. The leaks have stopped. TMB. Mercury. That's delicious. No, it's not good. It's not good for you or your body. Q says, what's in this jar? That is a jar. Q, first of all, that is a great question. That jar is a jar of spicy maple bourbon pickles, which are hot and spicy. They happen to be my favorite brand of pickle. They are sold at Walmart under the Walmart brand, which is like Select. I forget what the Walmart brand is, but it's the generic brand. Sold at Walmart. In my particular store, they've been taken off the top shelf and moved to the middle, which is more eye level. For most people, belly level for me, but the sooner they can get my belly, the better. They are spicy. They're a breakfast, like a sandwich pickle. They're good for breakfast, lunch, or dinner, but they do only come in that one size of jar, which I believe is single serving size. So highly recommended it. I think they're like I forget what the cost is. They're $3 or $4 a jar, but they're really really good unless you don't like spice, and then they're bad. Spicy maple bourbon pickles. We're a pickles, not politics channel as well. I have a bit of a pickle addiction. Let's see. Not found in the murder aisle, right? I tend to get them at the murder-free aisle, or the murder-free Walmart. If you have a neighborhood Walmart, it's the one that doesn't have the murder aisle. I like to go there because then I don't accidentally buy like evidence. Bug Dugger upgraded membership to jury. Bug Dugger, thank you very much. Welcome to the padded seats. I appreciate that. It's not Great Value. It's a different name. They have like Great Value is their generic name, and then they have like a premium Walmart brand name, store name as well. Can somebody tell me what it is? I cannot remember. Better Goods? No, it's something else. I thought it was Select. Something. Sam Select. There it is. Carol, thank you very much. Sam Select is the brand it's listed under, but it is packaged for Walmart. It's not made by Walmart, and so you can find these same pickles also at like Food Lion in identical jars. I mean, like literally, the jars are made by the same company. The lids are the same. They just have different wrapper on them. Bum was getting numb. Had to upgrade to a softer seat. Bug Dugger, I totally understand. Thank you very much. RA doesn't know the price or the name. That's because Mrs. RA does most of the shopping for food. I like to go with her when she'll let me, but she doesn't let me go often because I tend to add things to the cart when she's not looking. This last time I was able to add Thousand Island dressing and ketchup, which were not on the list. It has to be on the list to go in the cart. She's very good that way, but I like to sneak stuff in. Sam's Choice, I think it's Sam's Select, Sam's Choice. Okay, it's Sam's something, but it's not Sam's Club. I know that. Hey, can you blow out that candle? I'm worried some firefighters are going to show up in a little bit. Careful, it's hot. Don't spill. It's really warm, huh? Okay, just blow hard. Use your hand, it'll. Okay, now I'll just let the smoke just go up to the smoke detector. Thank you very much. Appreciate that. All right. Yeah, candle is out. I went off list. Yes, I do that regularly. No, we like the firefighters. You guys realize I'm in a home that was built in 1915. Valerie, thank you for the confirmation. It's Sam's Choice, and they are $3.48 at Walmart. OG Sean White stepping up, saying I can second this. They are good. They're really good. I like it. I would say the pepper, and usually there's 1 or 2 peppers inside. The pepper is hot. I think it's decorative. I don't recommend eating it unless you're like Ian Runkle. All right, we do have a court to go to. Thank you very much for the reminder, Josh. Judge Oakley's court. That was today. We are 15 minutes into verdict watch, and I'm going to keep an eye on. Oops. Keep an eye on. Whoa, Crazy Cat Queen said, been a while due to life. Think of y'all often. Merry Christmas. Happy holidays to non-Christmas folks. Yeah, Festivus for you guys. We'll do that on Monday. Merry Christmas to all the others. Crazy Cat Queen, thank you very much for super generous super chat. Let's see. We've got. Where's court 4? There we go. Okay, Josh, can you keep an eye on District Court 4 for me? I don't want to miss the Judge Oakley. Okay, there he is. Judge Oakley today. Thank you, Josh. Oh, my goodness. Whoa. Crazy Cat Queen's not done. Okay. Welcome to the gallery, Crazy Cat Queen. Good to have you back in the green. And then you brought 20 of your friends, which is just awesome. Thank you. Super, super generous. I see some great names in there. Love it. I think some of the OGs who've been overlooked for memberships for a while by the YouTube algorithm are starting to work their way back into the algorithm. I think that's a good sign. But Crazy Cat Queen, thank you so much. That is green. Green is the new green, says Adam. Todd Hudat. I saw Todd Hudat in there as well. Yep, M was in there. We got some good people who've been here a long time. Okay, I need to find the message from Josh really quickly. 59-minute mark. Got just a couple minutes to spend with the judge here. Okay, tell me if this is the right one.
Good morning, Graham, David Graham.
Is this it, Josh?
Good morning, Your Honor. Douglas Abraham. I'm here on behalf of Mr. Graham. Today's except for arraignment.
Good morning.
Formal reading and our please stay on mute. Get an opportunity to pre-try this matter with the prosecuting attorney. Mr. Graham is going to plead guilty to 2 civil infractions: careless driving and preliminary breath test refusal. The original charge is being dismissed.
Okay, I couldn't figure out what he meant keeping the B ticket. Now I got it. Okay.
Mr. Graham lives out of state. I can enter a responsible plea on his behalf. Facilitate it. He's had significant health issues.
Okay.
Was in a coma for 3 months.
Oh boy, you're lucky to be up and walking then.
8-year-old.
Yeah, good for you. Good. All right.
This is a fun.
All right. So, Heather, I'm going to take a careless, dismiss the misdemeanor, and then take a plea on preliminary breath.
Just Teresa, welcome. Thank you so much. Teresa and George, also welcome to the gallery.
Yeah.
Pay fines and costs today.
Okay. All right. And Mr. Graham, that's the way you want to resolve this today?
Yes, sure.
All right.
It's after this guy. You sent me a screenshot of what it looks like, right?
All right. Fines and costs on the 2 files together, $480. We can take care of that now?
Yes.
All right. Good luck with your health, sir. Go downstairs and that cashier will smile when she takes your money.
Thank you.
Yes, she will.
Thank you.
Okay, we need the guy with the hoodie with the blue on it. Let me see where he's at. Is that him? Oh, that's him. That's him. We're going to go back just a tiny bit. There we go. Let's see his approach. Okay, this is it. This is the one. It's
Jeremy Vick. Come on up, Mr. Vick.
Jeremy Vick.
Mr. Vick, are you going forward today without benefit of a court-appointed attorney? Where's your attorney, then? Who's your attorney?
I don't have one.
Then you're doing it without one, right?
Yeah.
Do you want to do it without one, or you want to talk to one of ours?
I'll do it without one.
Okay. Dude, get your hair out of your face. Yeah. I'm better. I can see you now. All right. All right. I've got a ticket here, and the prosecutor says you're going to plead responsible to double parking, and we're going to dismiss a misdemeanor charge of reckless. Is that correct?
Yes.
That's the way you want to resolve this today?
Is his mom there with him? His mom's back there.
Yes.
Okay.
Yes. Mom's here.
How old are you?
17.
All right. I understand you're almost done with school?
Yes, sir.
Then what's your plan?
I've been trying to get a job ever since I was 7.
Stop right there. Stop right there. Where have you been trying to get a job?
Trying to get a job at the service yard at Holiday Inn, at the apartments.
Holiday Inn?
Okay. Why do I have a ROA for a double parking? And we've already got a double ROA for it? Oh.
So everything.
It's confusing. No, it's not the way I'm used to saying it. I thought we had 2 tickets going.
Okay. This judge has a standing desk.
Where else have you looked?
I looked at the bait shop in Logo.
Okay.
And I also looked at Walmart and Buffalo Wild Wings.
And nobody's hiring you?
Well, Walmart, I don't know, but I can't get a response from Buffalo Wild Wings, and I'm trying to go to the holidays.
Okay. Okay. All right. You got a driver's license?
No, sir.
Yeah, transportation is going to be an issue then. All right. So what's your long-term plan? Done with high school, then what?
I'm trying to be an engineer.
So you're going to school somewhere?
Hopefully, that's.
Where and when?
Well, I graduate this year, and maybe I hope to go to college. Maybe by the time I'm 19.
Okay. What are you waiting for?
Engineer?
Nothing really.
Then why aren't you going to college now? As soon as you graduate?
Well, I'm trying to finish school right now.
No, as soon as you graduate.
As soon as I graduate?
Yeah. Why aren't you planning on being in school somewhere in the fall?
I mean, I really didn't think about that, but.
When did you start smoking dope? When did you start smoking marijuana?
When?
Yeah.
2 years ago.
Okay. How often you hit it?
Look at mom back there. Look at mom going.
That often?
What's that mean?
Like, barely.
What's that mean? Give me a frequency, brother. Once a month, once a week. Okay. All right.
Mom in gray is coming.
So on this file, you're not working now, so I'm not going to give you money. I'm not going to charge you fines and costs. I'm going to charge you community service hours. But I also have to give you a little lecture. Dude, I've been doing this a long time. All right? I can pretty much paint the picture of your life for the next 5 years. If you don't do something drastic. Okay? You are like the poster child for Mr. Laid Back. All right? If you're talking about going to school when you're 19, I can guarantee when you're 21, you'll still be talking about going back to school. Guaranteed. I mean, I would bet $100 of mine against one of yours that by then you could come back and we'd still have this conversation about your planning on it. Okay? If you were my nephew, I would put you in a car. I would drive you over to Canton on Ford Road. I would walk you into the recruiting office where you can talk to the Army, the Navy, the Coast Guard, Air Force. They're all in one building. And I would have you go door to door to door and find out what they could offer you if you sign up. Because that's what you need to do. You need to completely shake up your life to make something happen. Have you ever considered it? And I know you don't want to cut your hair, but it'll grow back. Have you ever considered it? Why not? Why? Because that's a valid reason. Wow, you got me with your logic on that one. Listen to me. How are you going to pay for engineering school?
Okay, well, if I get a job, I pay for it.
No, you can't. You can't pay for an engineering degree working at Walmart. You can't. If you join the military, they'll send you to college. You know, every one of the branches of our armed forces have engineers. There are Army engineers, there are Navy engineers. That's a plan, dude. You don't have a plan.
Okay, well, the officer that got fired, well, I did have a plan. The officer that got fired, he should be able to get help.
Officer got you fired.
Yeah.
Okay, where were you working?
The UIC fellow.
Okay, and how did you mean a cop?
Yeah.
How did the cop get you fired?
He was a member at the UIC, and when it happened, I guess he thought he had a reason.
You mean when this happened? Okay. All right.
The citation got me fired, not the officer.
I'll give you that, okay? How's that change what we're talking? We're not talking about this case now. We're talking about your life. How's the cop getting you fired determine whether or not you can afford to go to engineering school?
Because I wouldn't have a job to pay for.
The BYC isn't going to pay for 4 years of college, dude. What were you making? $15 an hour?
I mean, I was making about $14,000 a year, so I mean,
that ain't even going to cover tuition.
Okay, well, I'm also adopted, so you know, the state would pay for it.
Okay.
Okay.
I'll see you again. 30 hours community service. Have it done by February 1st.
I'll see you again.
Goodbye.
Mom looks over at him. He walks out the door. Mom's drumming her fingers.
Good luck. Bennett?
Trying.
Yeah, good luck. Who's on Bennett? There's no name on Bennett, so
okay, so stop. We're gonna go back. That was epic. That was an epic moment here. Okay, you've got to watch the mom. We've got to watch the mom here. Wait till when he says when do you start smoking dope? That's the part we're looking for.
Well, I graduated this year and
watch the mom, top right hand
corner.
corner.
To college,
gray shirt.
Maybe by the time I'm 19.
Okay. What are you waiting for?
Nothing really.
Then why aren't you going to college now?
Was this before?
As soon as you graduate.
Well, I'm trying to finish school right now.
No, as soon as you graduate.
As soon as I graduate.
Yeah. Why aren't you planning on being in school somewhere in the fall?
I mean, I really didn't think about that, but
When did you start smoking dope? When did you start smoking marijuana?
when?
Yeah.
2 years ago.
Okay. How often you hit it?
Her head. Boom.
That often?
What's that mean?
Like barely.
What's that mean? Give me a frequency, brother. Once a month, once a week.
My goodness.
Okay. All right.
All right. Wow. Judge, I've got to get that sound bite. Let me keep that playing here really quickly because I need a sound bite. Then that's not a planned part. All right. That was new to mom. Wow. Her head just about popped off. I've never seen somebody's reaction quite that much. I would just ask, if I were to send you out and get you drug tested right now, what's it going to show? What's it going to show? Give me a frequency, brother. Judge Oakley is a lot of fun. He has no filter. He occasionally uses some cursey words from the bench and does stand the entire time. He is one of my favorite judges to watch during a SOVSIT hearing. And believe it or not, first of all, he's just that up in your face throughout all of it. With the soft set, you think that could end in sparks, fireworks, not ending well, call the bailiff type thing. But in this last one he did, not this one here, but the last one we watched before that, he built a rapport with the guy. And he connected with the guy who's like, that's not my name, in all caps. And ended up, talking to him just real. And Chloe's mom. Yes, he spoke his language, street to him. It's awesome. I think we still have I think that Sovset still has a hearing coming up early next year, if I remember right. Josh is keeping the calendar for that one. Let me see where we're at.
For engineering school.
Is this back? I need the that's not a plan part.
No, you can't. You can't pay for an engineering degree working at Walmart. You can't. If you join the military, they'll send you to college. Every one of the branches of our
that was just epic stuff there. Let's see. He's surprisingly personable. I really like him. She almost gave herself whiplash. I feel for her because obviously her day with her kid getting a reckless driving ticket was bad to begin with. There's an offer where they get it reduced down to double parking, which is huge, and then she walks out of court finding out that her son is kicked back a little more than she expected. Oakley has a jury trial January 30th. The Sovset, that's the one. That's the one. Who do judges report to? The citizens, believe it or not, Sarah. It goes like this. Judges are appointed, and then they're reelected, or you get appointed by the governor or a political figure that has the authority over depending on your state how it works. And then every 4 years you're up for reelection, where citizens can decide if they want to retain you or not. It's not really getting elected, it's retained or not. So if a lot of people don't like the judge, they just say, no, don't retain. A lot of people have the philosophy that the judges are like dirty diapers or like diapers and should be changed often. Just vote to switch all the time. But I think there's some good judges we ought to keep around. All right. Don't think that kid would make it through boot camp. I think I got the part we wanted, hopefully. All right, let's go back to Thurston. Keep an eye out on Thurston, Washington for the verdict watch. Okay. Thurston County Courts, 4. There's 4. They're not back yet. Could be a bit. We'll see what happens. All right. Unless there's no one else on the ballot, then they get to stay no matter what. I think you can vote not to retain because it's not like who gets the most votes. If you vote, if the majority wants them gone, then there's a vacancy that would have to be filled by appointment. Depends on the state, though. You might be right. What's the verdict clock? I don't have it on the screen because I haven't plugged in the little device I got today, which is also going to be Mrs. R.A.'s camera feed. But we're at 33 minutes right now. Can we please hear another song? I don't have any songs you haven't heard, I don't think. Because there was a hearing today in the Courtney Clenny case. The Courtney Clenny case, for those that haven't followed that one, that particular trial is one I think there's a lot of curiosity about, but most people I think could not follow it because you can't see the evidence. Or you can't see the evidence and also keep your YouTube account because Courtney Clenny was a adult model, actor. I don't know how you want to call this. Adult ballet. What do you want to call that, Ivan? She worked on OnlyFans. And a lot of the evidence is literally from her site. She's accused of throwing a knife and stabbing her boyfriend in the shoulder, and he bled out. He died. Then, to complicate everything, the parents at one point were charged with destruction of evidence over a laptop and things like that. She's highly successful financially, but there was a hearing today in that case. And because of that, we'll play our version of the OnlyFans situation. And this is called, it's not about that case. This one's about Grandpa. So let's play the one from Grandpa. Here we go.
Old man Joe just turned 74. Found a website, thought it was for more. Sharing stories about his younger days. Cooking breakfast in his own kind of ways. Signed up quick, put his pictures on. Fishing trips and mowing the lawn. Didn't know what it was all about. Just sharing life with no second doubts. Grandpa's OnlyFans, spreading love worldwide. Folks tuning in, can't put their phones aside. He's gone viral, making money with grace, unaware he's in a different space. Neighbors whisper what they say ain't kind, but Joe keeps on, he don't seem to mind. He's buying tractors, fixing up his place with the earnings from his newfound fame. He reads their comments, laughs out loud. Grandpa Joe, you make us proud. Still oblivious to the site's true start, sharing his life straight from the heart.
Jimmy, I'll answer this in a question in a minute.
Brings his grandkids on for a morning chat. Shows them how to fix an old straw hat. They think it's funny, but they don't tell. Just let Grandpa's stories ring like a bell.
There we go. Grandpa's OnlyFans by request. All right. As we now reach about 37 minutes. Oh, I guess it keeps going. It's got a quiet ending. I'm gonna fade it out. We've got like 2 endings in the song. I need to trim that one down. Jimmy asks a pertinent question here. How much jail time can this one get? I want to answer this, but I don't know exactly because I guess we'll spoil it right here. It appears that the defendant has prior arrests for assault. If that is the case, if the names match up, and the county does, and the name seems to match up, if he has priors, depending on how many priors he has, how many offenses, it completely changes the penalty. You know, if he's back, for round 4 in this field, suddenly 10 years is on the table. But if this is a first-time offense and it's not the same guy, and there's no prior convictions for that, he could just get probation. And so there's a range. There's a range there. It looks like he's got possibly some priors. So the jury does not know this. The jury doesn't know. The judge will be informed. I'm sure the prosecutor, if there is a conviction, the prosecutor then comes in and says, okay, now we want to raise these priors. The judge knows they're there, and he talked about it beforehand, just said, you can't bring that up. If you think for some reason the door has been opened to these prior acts, before you say anything in front of our jury, come up and talk to me. We'll see if it has. That didn't happen during the case. So Prior arrests are different than prior conviction. Yes, we just did some searching and found news stories with prior arrests, and possibly even a post-arrest. So it's a little up in the air. So we were going to wait and hear what the prosecutor says if there is a conviction, and that they'll tell us. The judge will spell it out for us, but it could be bad. Let's see. I can't. It hurts my soul. Music hurts your soul, Jen? Is that what you're saying? I mute all music because it reminds me of my son who died from a heart attack. Oh my goodness, I'm sorry. Music was his world. Jen, I'm sorry. I'm sorry that it hurts you. It means a ton to me. Music has got me through some difficult times, and that's why I share it. I don't do it to pain you. I apologize for that. Virginia says, that one sounded like something I've heard before. That's what you hear every time you hear a song from Suno, because I believe Suno is getting sued. They've trained their AI on professional singers. So you're like, hey, that sounds like Garth Brooks. Hey, that sounds like Brooks and Dunn. Hey, that sounds like Reba. Hey, that sounds like Dolly. That sounds a lot like... Yes, it does. For obvious reasons. It does. Let's see. Oh, Josh says he's got another one. Another good one from today. From Judge Simpson. We like Judge Simpson. Let me check once more with... Jury's still out. We're at 41 minutes, just past 41 minutes. Let's jump to Judge Cedric Simpson's courtroom really quickly and see what happened today that got Josh excited about this. Judge Cedric Simpson. Can never get this right. Judge Cedric Simpson, YouTube. Why can it not? I just want his channel. Not like the million people who have posted something about him. Judge Cedric Simpson, YouTube. There it is. There it is. Top result. Okay. Today, let's see, we've got a timestamp of 4:45:52. I'm just a touch behind that, but we'll jump in there.
Yes,
Mr. Benson?
Yes, I'm here.
Okay, I need a camera. Okay, there you are. State your name.
Have a seat, too.
Mr. Benson, can you state your name, please?
Sean Benson.
Thank you. You'll need to get someplace stable.
Yes,
all right,
sir.
what are we doing?
I'm working on it.
Your Honor, we are asking for an adjournment to continue plea negotiations.
I'll adjourn probable cause conference. January 9th, 2025, 9 a.m. Well, continue, yeah, whatever.
Thank you.
No, you're helpful in some way.
Josh is amazing at this.
Court calls the case, People versus Lawrence Watkins.
Oh, here we go. Lawrence Watkins.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Watkins, who's present. Judge, state your name, Mr. Lawrence Watkins. Your Honor, at this time, I believe Mr. Watkins will be waiving his preliminary examination.
Before we do that, we have a violation report. You can see that.
Yes, Your Honor, I did see the report.
A violation report. What did you do wrong? It's on bond.
What do you want?
Your Honor, I did. I received the report yesterday. I haven't seen any of the underlying tests. It's my understanding that there was a positive test for cocaine several weeks or in mid-November, if my recollection serves me right. He was counseled for that. It was he has not had any other positive tests since. There has been multiple tests. Your Honor has the report.
I do.
Your Honor, Mr. Watkins reports that he has not used cocaine. He has not used marijuana since being ordered not to. And those, that's why I was hoping to.
Hold on, before he says that, if you want me to call over and get the amount.
Well, that's what I was wondering, Judge, if the lab amounts were going, if the amounts were going down progressively with each test, that would be indicative of.
Can I speak, Simpson?
You can if you want to, but you might want to let your attorney talk to you.
No, I don't mind speaking at all. I mean, as far as the marijuana, Mr. Simpson, like I said, since the day I've been going over there, I haven't smoked weed since. And I have no reason to lie to you. Why would I lie to you? I can just tell you the truth. I would just tell you, yes, I smoked, but I haven't smoked marijuana since. As far as the cocaine, like I told my attorney, I was going through my old clothes. Like I wouldn't lie to you. I would have no reason to lie to you at all. I'm doing great in my life. I'm doing everything I'm supposed to be doing. I showed up to court. You didn't have to put a warrant out for me.
Can you order the results of the marijuana? I need levels.
Yeah, please. I haven't smoked at all, period, Mr. Simpson. If I did, I would tell you I have no reason to lie to you. And I can just simply say, yeah, I smoked. I slipped up here and there. But I never have. I never smoked since the day I've been to the report, not one time. Not one time have I smoked, period. Not once.
So what's up with the cocaine?
I told you, like I was going through my clothes. I can talk. I don't mind talking. And I found some cocaine in my pocket. The only thing I did was took it out of my pocket, Mr. Simpson. That's all I did, and took it straight to the. I could have sold it. I could have did a whole lot of stuff with it. But I told you I'm doing so good in my life right now. I took it straight to the toilet stool and flushed it. I have no reason to lie, Mr. Simpson.
Why is it showing up in your system?
I don't know. I just touched it, Mr. Simpson. I never used cocaine in my life, ever. Just touching it.
You know,
Mr. Simpson, I would never.
No, listen. I've been doing this for a minute. I can't believe you're like an amoeba. What, are you absorbing it through your skin like that?
Yes, Mr. Simpson.
Oh, okay.
Mr. Simpson, I promise you.
Give me the levels on the cocaine too, please.
Yeah, please, Mr. Simpson, I wouldn't lie to you. I have no.
Okay.
Why would I lie to you?
Here's what I'm. Yes.
The levels for the cocaine were actually included in the original report the court has. It's a pretty small print. It does say 162 nanograms per milliliter for the cocaine.
Oh, I see it. They put it in there.
And it was confirmed.
Everybody check.
And I sent that to the. I had. Go ahead, Mr. Simpson.
I don't know how you get 152 milliliters. How do you do that?
Can I talk, Mr. Simpson?
I would.
Well, you've been talking.
Oh, listen, please. Let me clear this up to you. There's no.
You're not doing a very good job,
Mr. Simpson. I know you want him to talk, but let me talk, please.
No, I'll let anybody talk that wants to talk to me. I'm just telling you, you are not helping yourself.
I know. I don't see how, since I would never lie to you, ever. Ever. I've never used cocaine in my life. Only thing I did was touch it. Ms. Willard was right there when I showed her. And I took it straight to the, I don't know if it stayed in my system when I flushed it or whatever, but I could take a lie detector test. I never used cocaine in my life, Mr. Simpson.
How does it stay in your system when it didn't get there?
When it didn't get there.
You took cocaine out of some old clothes.
Right.
Took it right from there to the bathroom.
I didn't say old clothes, out of a jacket I had that was in storage, Mr. Simpson. I would never.
And then I know you would never lie to me.
Okay.
And so then you didn't do anything with that cocaine.
Mr. Simpson,
and then somehow or another that gets into your system at these levels.
Mr. Simpson.
Oh, you got to be kidding.
Okay,
let's tell you what we're going to do. I'm going to wait for the levels to come across. In the interim, Mr. Allen, take him back, put him in, and then we'll bring you back out, and then I'll do that.
Okay.
I'd let you talk.
I know. Can I just say one more thing?
Sure.
Listen, Mr. Simpson, this is what I'm trying to tell you. I call every week and go drop, right? If I'm using cocaine There's no way in the world I would have went over there and dropped. I would have came in, I would have called over there, told him something, and missed the whole thing, Mr. Simpson. I would have missed it. I would have made an excuse. I would have went to the hospital. Or I could have said this. Oh, somebody put some cocaine in the weed, and I accidentally smoked. And it was in the weed. I could have told you all of that. But I'm telling you the honest to God truth, Mr. Simpson. The honest to God truth. I did not smoke no weed. And if I'd have did that, I could have told you that. You're a fair guy. You've been fair with me every time I came in here. Every time I became a senior, you always been fair with me. So I wouldn't stand in front of you and lie to you. And if I did use cocaine, I would ask for help. I've been doing good for 18 months, period. Working every day, taking care of Miss Willer's grandmother for 10 months straight. I never lied to you, Mr. Simpson. I wouldn't do that when I know I can ask you for help.
Okay. I'm going to get levels and then deal with your case at some other point. But right now, you're going to go with my bailiff. We'll get that information, and then we'll bring you back out.
Today?
Yeah.
Okay, Mr. Simpson.
Unless you want me to.
No, I don't.
Okay.
I really
but if you
don't.
keep talking, it's going to be tomorrow.
All right. Thank you.
Okay. Stop talking. Good. There we go.
I wouldn't lie to you.
Okay. I know you wouldn't lie to me.
I wouldn't lie. Okay. Judge isn't buying it. Poor attorney.
I'm an amoeba. Leave me alone.
I'm an amoeba.
I'm not going to read these files. I'm just going to absorb them. What? Court calls the case, People versus Hannah Wellman. I mean, he might be right.
Okay.
I don't know about that cocaine now.
Hang on, I need my phone back for my kid. Hang on 1 second.
Andrew Childress appearing on behalf of
Ashley Moan, assistant public defender, appearing on behalf of Ms. Wellman.
Your name?
My name is Hannah Wellman, Your Honor.
All right.
Hey, Josh, do they come back?
Requesting an adjournment.
If so, what time?
All right, I'll adjourn the matter. Probable cause conference will be reset.
I don't have my phone.
Adjourned
If you can put it in
to
chat.
January 9th, 2025, 9 a.m. Bond continued.
Is it possible we can get a little more time just for the mitigation report?
This is what I'm talking about. You were so nice all day.
I am nice to
No, and then all of a sudden she's like,
Asking for stuff.
She started yelling at me. Did you pass? Did you see that? It wasn't just.
Say no, don't
Judge,
agree.
Could we please have a couple more? Hey!
Judge me.
No, she was like, no, never mind. No. Right. Well, will the 16th work for you?
Yes, that will help. Thank you so much.
Okay. I'm going to see if I can find the return.
January 6th. Really?
We're going to find the return there. Let me see. Oh, thank you. All right. Let's see. Verdict watch, we're at 52 minutes. Towards the end of the stream, he comes back. Let's just see what the levels were. That's not it. Trying to find it here. That's not it. Yeah, it was someone else's pants excuse. Can work if you find $1. But if you find a bag of cocaine, the Goodwill story is a hard sell. It's a really hard sell. Somebody said 650. Okay, I was almost there. I was at 640. It's right at the very end. Dan, thank you very much for that. Okay, give us us just a minute. We'll be back with the judge here. 6:50 as she comes back. It's only 4 o'clock in Washington. Yes, they're on the West Coast, so they really push us right to podcast time. Waiting for the judge to pop back on. We are on verdict watch, Lil Graham. We are with the case out of Thurston, Washington, a road rage case with a lot of different stories. It's not coming back.
No.
Let's see. I think it's right here. 5 seconds or so. Still light out, says DK in Washington. You'd never lie to Mr. Simpson. Never. Why is it not starting where I tell it to start? Okay. There we go. Here we go. We've got the attorney, his attorney there. Looks like he's the last person up.
I got one left. They may be seated. I'm sorry. What do you want? Nicole and Nancy just sat out. They said, I'm tired. No, it's okay. Well, so did the young lady back there. I think I did.
Mr. Allen's sending a quick text. That's the bailiff.
I have to stand. At my age, if I get up too many times, I make that old man noise.
Well, I would just say, I don't know how far over you can get when he starts talking to me. She did? Did you call him?
Certain, hopefully it was right.
You know what, Emily? Yeah, it's time for you to have a vacation.
Why doesn't my boss ever tell me that? It's time for you to have a vacation.
Court does call the case of the people of the state of Michigan versus Lawrence Watkins.
Ashley Lonnie for the people.
Mike Gaddy, Assistant Public Defender, on behalf of the defendant, Your Honor, who's standing here on my right. State your name.
Lawrence Watkins.
All right. Couple of things. First of all, we have sent to counsel the levels.
Yes, Your Honor, I did receive I did receive them both by email and a printout, and I have shown them to Mr. Watkins. I would.
And he's as mystified as the rest of us.
They do. This is for THC. I'm assuming it's for the metabolite, not active. They do show that they are progressively going down, and then they. Well, this document speaks for itself. Obviously, there is a slight jump from 1210 to 1217 of about.
Slight.
Well, I mean.
Okay.
Well, when we look at
to where it was, yeah.
Yeah, and I mean it's 28. I think the bar graph is probably it starts at 60. I mean, if it started at 0, 1210 and 1217. 1210 would be about 2/3 the size of 1217, not 1/10.
A lot of math.
It does. I don't know if certain things. Obviously, our body metabolizes things at a different rate. There's a significant reduction in the late month of in late November, and I don't know if these metabolite levels can go up with things like hydration or just how active we've been in the way our body's metabolizing. I do know that since October 29th, even in the worst case scenario, these levels have gone down well over 100, looks like over 130 points. I'd ask the court to, if the court's concerned,
judge is shaking his head
about this,
He needs to just tell me, and I don't mean to interrupt you, Mr. Getty, but he needs to just tell me the truth. I mean, that, you know, we can sit there and play this game, but the cold-hearted reality of what happened is he almost goes down to a zero after it kind of falls off, and then all of a sudden it just shoots back up. Then he's trying to tell me that on the 19th of November, that all of a sudden this cocaine through some osmosis process, I don't know how that all of a sudden just gets into his system. So he's just got to start being honest and don't sit up there and say, I wouldn't lie to you, Mr. Simpson, because this tells me you did.
Mr. Simpson, I would take a lie detector test for you. I would go over there 3 days. Okay.
Your Honor, I'd ask the court to, it looks like he's been testing every 7 to 8 days, maybe increase it to 2 or 3 times a week to allow him to demonstrate that these levels will continue to go down and that there will be no further cocaine tests. Maybe bring us back in 2 weeks, revisit this issue on a adjourned PCC if the court's inclined to do that. This was going to be a waiver today, but I can understand the court's concern.
I'm going to adjourn him out 1 week to the 26th, 2024, 9 a.m. This time, based upon what the court sees, defendant's bond is revoked, he's remanded.
Boom.
Your Honor, if I could say, one other thing is that he's been working steady for the last 18 months. He is a caregiver for his significant other's mother. His life is a much markedly different thing now than it was even in October. This is
Well, he needs to tell me the truth.
Hold up.
I mean, no, you hold up. Don't tell me to hold up. You sit up there and tell me.
I'm not lying to you, Mr.
Oh, we don't want to do that. We're done. We're done.
Do not smoke weed, baby.
We're done.
I never.
We're done.
Listen, I'm not lying to you.
You do not yell at me.
I am not lying.
Do not yell at me. Ever.
Hold up.
No, you do not hold up.
I'm telling you,
Mr. Simpson. Do not talk to me that way. You do not talk to me that way.
I'm not talking to be disrespectful.
Ever.
But I came in here when I was full of garbage. You worked with me. Now I'm telling you the truth, and you telling me I'm lying to you? I have no reason to lie to you, and I know I can tell you the truth. When I used to come in here and I have nothing to stand on, you gave me every chance in the world, Mr. Simpson.
I did. That's why I
can't believe it.
Why I expect the truth from you.
That's what
I'm looking at the graphs.
Even when I came in here, I was full of garbage, Mr. Simpson. You let me go. I'm telling you the truth now, and you think I'm lying to you? I'm taking care of her grandmom. I've been doing this for 10 months straight. I've been working. I'm paying child support. I got my name on the lease on the house. I never came in front of you and I had these things accomplished. Now you think I would lie to you? When I know that you're a man and let me finish talking, please. I didn't mean to yell at you, Mr. Simpson. I got the utmost respect for you, and I always have. I'm sorry. But I wouldn't lie to you, Mr. Simpson. I promise you, I'm so sorry for raising my voice. But I wouldn't lie to you when I know I can tell you the truth.
You don't ever do that to me.
I'm sorry, Mr. Simpson.
Shut up right now. You don't ever do that to me.
I'm so
shut up.
I can't believe you do it.
And I know my mom taught me better than that, but you better shut up. Shut up and turn around. Just shut up. Whoa. I sat up there and I listened to you. I did all of that. I don't believe your story about the cocaine. What I was serious, do not say another word, because if you say another word, you're gone. I'm done. I went over and I said I was hoping that the graphs would come back and they would indicate to me that you had not used THC. I was hoping there was something in your story.
Man, I ain't lying to you. Hey, babe, what's the phone number? I'm sorry, just take me easy. Babe, what's the phone number?
Go.
What's your phone number, babe?
Just go.
He said, yeah, babe, I'm tired. I ain't lying to you. You think I'm lying to you? Just take me down, man. I ain't not lying to you, man.
Ma'am, I'll hear from you, but he's not here. I'll hear from him.
Now we have interested party wants to talk to the judge.
What's your name?
Amanda Marie Willard. I don't know about the cocaine issue. I wasn't around for that. We got into an argument, he left, and then he came back and said that he dropped 30 for that. The weed he has not smoked at all since I've been, since he had to start dropping.
Can I just say?
I don't understand why he came in here and was like that. But ever since we've got together, he hasn't been in the streets. He hasn't been selling drugs. He's got a job. He helps me take care of my grandma who has Alzheimer's. I can't have him locked up. I don't have nobody else to help me take care of my grandma right now. He's really not doing anything but working, and he stays home with my grandma when I'm at work, and that's it. He doesn't even leave the house.
Yeah. Let me just say this. I've worked with him before. And the thing is, what I saw today, I've seen before with him. But I was hoping one of two things. One, that he would just really tell me the truth. And then, if not, and if he was actually being truthful with me, particularly about the marijuana use, I don't believe about the cocaine use. And I get what you're saying. You weren't there and whatever. I get it. That what he was telling me was the truth. But then I get the levels. And I'll just describe it to you this way. He's at a certain level. He goes down. And then it levels off. Okay, then he drops to basically almost zero. And then, what was that, the 17th? I want to get the dates right for you. And then the 17th, he pops back up again.
I can't explain.
And so
I just know that he lives with me and my grandma. He's not smoked though at all. So I don't understand that part. I don't know. Okay, so does he have a bond? Can I pay his bond right now? I have to be to work at 5 and I have nobody to sit with my grandma. I don't know what to do right now. He's not a drug addict. He doesn't get high. I'm a heroin addict and I've been sober for 6 years. I wouldn't be with somebody that uses drugs right now. And I wouldn't have him taking care of my 84-year-old grandma either. I wouldn't leave her alone with him if he was selling or using drugs. I smoke marijuana, but I am not on probation or anything. I can drop clean for everything except for that. And I thought he could too, but I don't know. Can I just pay a bond or something?
If she smokes around him.
Dear God.
If she smokes around him.
Are you from Milan?
Yeah, you know who I am?
I know. Oh, man.
We just went through a whole court thing with my grandma. My mom was neglecting my grandma. She has Alzheimer's. And I went to court. We won in court to get her. And I just don't have anybody, no brothers, no sisters to help me take care of her.
Stop. Is that the grandma that was taking care?
Yeah, my grandma Susie. She told me to tell you hi. She said you have to be about her age by now.
Wow. Okay. But that's grandma that was running after all of you Willard kids.
Yeah.
Okay.
I'll be responsible for him.
Hold on. Don't do that.
I will. You can take my whole check right now.
How much can you pay him in?
I have $200 on me right now, and then I get paid tonight. I'll have $600 in the morning, and then he gets paid tonight at midnight.
judge knows his whole family. He knows the whole situation here.
Good Lord, I don't even know why. I'm gonna set his bond at 5,000. I'll give him a 10% privilege, so you need to pay 500. But I'm gonna tell you what. You've been before me before. Probably every Willard and has been before me. You know how I am.
The whole family.
So you better talk to him. If he comes in here again yelling at me, not listening, trying to manipulate and do whatever, I'm revoking it. I'll leave it, his bond, to next week. But I'm going to trust you on one thing, and that is that you go talk to him, that you talk to him and tell him, I'm not playing. He knows that.
Can I talk to him right now?
No. So he's going to go down. It'll be $500 that you got to post. Post it by that time, okay?
By what time?
You can post it tomorrow if you can't come up with 500 tonight when you said you get your check and you have the 200.
Well, where can I pay it at?
You can pay it at the jail. You have to pay it at the jail. Because
Down there or up front here?
I think it's up front.
Okay.
During business hours and stuff.
Yeah. It's right during business hours it's up front. Where is it after hours? IITR down there. Okay. All right. Okay. I don't know why. I'm gonna trust you. All right.
Well, I mean, I feel like if I can get my life together after 20 years of street, so can he, and he's working so hard to set himself back. I don't know why he just came in here and showed out like that. I really don't.
I don't either.
I really don't know why he did that.
Then you need to talk to, I'm going to trust you to talk to him about
I swear I'm going to do more than talk
because
to
you
him.
know how I am, and I'll be straight with you. I'll do what I got to do, but you're not going to come in here treating me like that.
No, I know.
Okay.
Thank you.
So I'm going to leave that part to you. I'm going to trust that you're going to do what you got to do. All right.
Okay.
Tell your grandma I said hello.
Okay. Thank you.
You're welcome.
What a day. The attorney's like, I argued to get him out, and you wouldn't do it for me. That's how the judge is like, cut the feed. We're done. We're done. Big heart. Look, Lady Draconis, he is a treasure. We are still on verdict watch. We're an hour and 12 minutes. It looks like this is going to be a podcast interrupting verdict watch because we're less than an hour away, 45 minutes away from a podcast, which means we have to stop this stream to start the other one. Maybe if we go ahead and do that, that will give the courts up there in Thurston, Washington, the jury at least, the impetus to get it done, reach a verdict. Thurston County Courts, 4. Not back yet. I'm showing a 1 hour and 12 minutes on the deliberation timer. So we're going to take a break. We'll be watching for that. I'll be recording it if it happens, and we possibly might interrupt the podcast with it. I don't know. We've got some good stuff to talk about, so maybe we'll be able to do the verdict tomorrow morning if we have to. But what a day! Oh my goodness, we've seen some crazy things today in the world of true crime. It's wild. Where can we watch on our own? YouTube. Chloe, you can watch on YouTube. We're going to be here. I'll be keeping an eye on this. Obviously, we've got some amazing mods and amazing people in the community will keep me updated on things as they develop, in this case out of Thurston, Washington. Verdict Watch continues. Podcasts coming up in less than an hour. I'll need just a teensy break before we start, so I'll make the, actually, let me portal you guys over to the podcast. Does that work? See if I can make this happen in time. Oh, no. They messed it up. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again at 8 o'clock with the podcast and possibly a verdict. It's happening. It's happening tonight, I think. I'm feeling it. Okay, we've got the podcast created. When we build the link, we'll portal us over to the podcast. That would be great. I've got 2 of them. Which one did I mess up on? I don't know. I'll figure it out. Give me a minute. I'll have a splash screen on the screen and a dead mic, but we're going to get this link created. Here we go. It's going to take a minute. I've got to delete these 2 upcoming videos because I made them wrong.
Have them send someone with more experience.
Thank you, Mr. Farag, for your vote of confidence. Still here. Hold on tight.
Oh.
Because he's the guy.
Still working. All right, there we go. I've got it built. Portal incoming. See you in a little bit.
Now let Murdoch stall it.